Okay, discriminatory harassment policies.
Wow, what a difference that is, turning off that ventilation there. I feel like I have to shout now.
Anyway, harassment policy. This is a policy that since 1998, specifically a pair of U.S. Supreme Court decisions in 1998 that created a great incentive for employers to have such policies. Specifically, the Supreme Court said in these decisions that if an employee is subjected to harassment by a supervisor, and if the employer can show that even though the employee truly suffered unlawful harassment, if the employer can show that it took reasonable measures to prevent and correct any potential harassment, and secondly, the employee failed to avail him or herself of those measures, the employer will win that lawsuit, even if the employee actually suffered harassment. So what came out of these decisions was a great incentive for employers to have harassment policies, do harassment training, really focus on this with the goal being employers address these issues in-house. The courts don't want to necessarily be bothered with harassment claims because quite frankly, if one could run to federal court every time one felt that he or she was harassed at work, things would be even crazier than they are now. So we have this situation where we have a great need to have harassment policies. We list on page 17 what should be in the harassment policies. A couple of points. It's not just sexual harassment. Harassment can be on the basis of any protected trait. While sexual harassment is perhaps the most well-known and common form of harassment, harassment on the basis of religion or race, really any sort of mistreatment of an employee that is so severe or pervasive that it alters the employee's working conditions, that could be potentially unlawful harassment if the harassment was on the basis of a protected trait. So your harassment policy, if you just have a sexual harassment policy, that's not enough. You need to make sure it's a discriminatory harassment policy. And perhaps the most important aspect of a harassment policy is the reporting procedure. Explaining to employees that, look, if you believe you've experienced or witnessed anything that violates our harassment policy while at work, report it to one of the following individuals. And I recommend having at least 2 different positions or persons listed as options for the simple reason that if the alleged harasser is the one person to whom harassment can be reported, that's not a good thing. So you want at least 2 people listed as potential people to whom harassment can be reported. I do not recommend having a policy that says report harassment to any supervisor or manager. These are big deals, meaning the law compels us to investigate potential harassment situations, and it's not advisable to allow employees to report it to any supervisor. Oftentimes the alleged harasser is a supervisor, and courts have said if your policy says any supervisor and the employee says to the supervisor, stop it, that's reporting the harassment. In reality, no one in upper management knew about it. So that's why I would recommend that you have your reporting procedure be district manager or assistant manager, or if you don't have an assistant manager, district manager, and perhaps the chair of the personnel committee on your board. I mean, there's no one size fits all, but have more than one potential person to report it to, and secondly, make sure that it's not all supervisors. Training, it's not a bad idea to consider training. It's something, again, the more that we do to show employees this matters to us, if you're having any issues, report them to us, the better. Short of training, even whether you do training or not, I recommend the handbook you hand out to new employees and when you revise it. The harassment policy I would distribute separately on at least an annual basis to employees. Because if you've got an employee of 10 years and your handbook's 10 years old, he or she likely has not seen the harassment policy in 10 years. It's a good practice to redistribute that policy once a year and just send it out. Could be electronic, a PDF, an email to your employees just saying, want to remind all employees of our harassment policy. Please read it. If you feel that if you have any concerns, report it to one of the following individuals. The end. Again, it just helps us in the event that an employee ultimately brings a claim and we never knew about it before the employee brought the claim. We can show, look at all we did, court, to advertise this policy. This matters to us. This is a big deal to us, and this employee didn't report it as he or she should have. It's part of that whole professionalism, looking like, making sure that we confirm to people that we care about this stuff. It's very easy to do, to redistribute the policy once a year, and it can really make us look good in the event of something troublesome happening. General guidelines for conduct / progressive discipline. It's good in any handbook to have a non-exhaustive list of the types of conduct that we do not tolerate as an employer. The keys are to make sure that it's very clear that it's non-exhaustive, because no matter how many pages you make that list, you'll find an employee that will do something that is not desirable but doesn't fall within one of the 78 categories of misconduct listed there. So that list is a list of examples, and you have it there. You make clear that the reason why it's helpful is many times, for example, in unemployment compensation, the UC system will say, well, what are your policies? And if we can show, look, we had a policy against falsifying or district documents. It's right here in our handbook on our list of guidelines for conduct. Employee A falsified this document, slam dunk, we win that UC case. The other thing you want to make sure you have, if you mention progressive discipline, and what is progressive discipline? Verbal warning, written warning, suspension, termination. We follow in steps. We progress through the disciplinary process. It makes sense to have policy like that, but you want to make crystal clear that the district reserves the right to administer whatever level of discipline it believes is appropriate in any situation. You don't want it written in a way that somebody comes in and punches someone in the nose and burns the building down, and you look at your policy and says, well, we have to issue a verbal warning for that. I mean, you want to make clear that certain offenses may trigger skip steps, and may even go straight to termination as a one-time offense. Appropriate attendance policies. There are really two general types of attendance policies. One is it's referred to as a no-fault policy, or one of those points-based or occurrence-based policies that say you'll get an occurrence for each absence. If you get 4 occurrences, that's a verbal warning. 5, it's written. A step-by-step policy like that. The other type of policy basically says we expect regular and acceptable attendance by all employees. Failure to maintain a satisfactory level of attendance may result in disciplinary action up to and including termination, period. I like the second kind better, especially for smaller employers like yourselves, because whenever you have a points-based system, you're inevitably going to find employees who figure out how to game that system and figure out how many days of work they're going to take off, and not suffer the potential disciplinary action up to termination. So you're almost inviting employees to miss X number of days per year, whether they have a good reason or not. And secondly, the law right now is very much, the EEOC and the government enforcement agencies are very focused on no-fault attendance policies and counting absences that may be covered by the ADA or the FMLA, meaning these are absences that are protected by law. And if we have a no-fault or points-based system, we can't issue a point if someone's absent and it's otherwise protected by law. So I like having the more general policy. For larger employers, having a more rigid, formal, points-based policy makes sense, because you want manager A and manager B to enforce the same policy. You don't want manager A to let people miss 10 days and not do anything, and manager B fire people after 5 absences, because that looks inconsistent within the organization. But with centrally managed smaller employers like yourselves, I would advise just having a very simple policy that just says we expect regular attendance, and if you don't meet our expectations, you may be subject to discipline. We still should shoot to be consistent across the board. I mean, we don't want to fire somebody for 2 absences when someone else misses 15, but it gives you the flexibility to handle situations in the manner you think is most appropriate, and it doesn't telegraph to employees how many days they get to miss work without triggering any sort of adverse disciplinary action. So take a look at your attendance policies. If you have a points-based system and it works, fine, but make sure you're not counting absences that are otherwise protected by law, and we'll talk a little bit about that in a few minutes. But if you're starting from scratch, the simpler the better, from my perspective, on an attendance policy. Electronic communications policy. This policy is what addresses employee use of district-owned or provided electronic communication tools. Internet, email, voicemail, if you provide mobile phones to your employees, cell phones, if you provide social media access, anything that you give employees This is what this policy would address, the do's and don'ts associated with that. A couple of key things any policy should have. One, you should make very clear to employees that they have no expectation of privacy in anything they may do using your electronic resources. You may, hear the term, that's an invasion of my privacy, invasion of privacy. And there actually is a legal claim based upon invasion of privacy under the common law. But to state an invasion of privacy claim, someone needs to show that I had a reasonable expectation of privacy and that expectation was violated. If we make clear to employees, look, we may monitor your use of our electronic communication tools, we may monitor email, we may monitor those things, the employee has no reasonable expectation of privacy, so there is no privacy claim. Now, does that mean you should be reading all of your employees' emails all the time? I wouldn't advise that, but you need to have that access, because if a situation arises where suddenly you get an allegation of misconduct by an employee, you may very well want to look at that email and see what's going on, and you want to make sure you preserve that right in your policy. Another thing to think about is non-work-related use of our electronic resources. For a long time, I've seen a lot of policies that say business use only, no personal use at all. To which I respond, go back to what I said before, have your policies reflect your culture, have it reflect your reality. What I've seen is very few employers who enforce a complete ban on non-work-related use of all electronic resources. Do you have employees who check the weather, who check CNN on their computers and things like that at work, who maybe go check their kids' soccer schedule before they leave work, things like that? You're probably thinking, well, I don't have a problem with that kind of use, and that's fine. But don't have a policy that says no non-work related use if that's not what you're going to enforce. What I have generally advised clients, at the bottom of page 21 of the written materials is some sample language to put into a policy. Limited personal use is permitted so long as it does not interfere with the performance of your job, consume significant resources, give rise to more than nominal additional costs, or interfere with the activities of other employees. Most employers I interact with, that's generally the way they enforce their policies. Look, if you want to make a personal phone call, or if you want to send an email out to your kid's soccer coach, so be it. We don't have a problem with that. Where we have a problem is where it starts to affect your job, or affect you getting your job done, or affect other employees, or start consuming our resources. If you're suddenly streaming live video at work, and it's eating up all of our bandwidth so that no one else can access the internet, that's a problem. I recommend having a policy like that, because what happens is if you have a strict ban, no personal use, you're going to enforce that against the person who spends all day on the computer, personal use. And when you go to enforce it, that person invariably is going to say, well, yeah, okay, I was on those websites, but Sally's on these other websites all the time. Well, Sally's on those websites 10 minutes a day, and this person's on the websites 5 hours a day. Well, obviously, we're going after the employee who's using it 5 hours a day, but according to our policy, no personal use is permitted. So that's why you want your policies to reflect your culture and your reality, to avoid situations where, frankly, you look bad, where you have employees who can point to your policies and say, you don't follow your own policies. That's something we never want. And that actually touches on another point that doesn't really fall under any of these, but as a general rule with an employee handbook, I do not like having handbook language that includes management directives. Managers and supervisors should, ... The reason why is an employee handbook by definition goes to all employees. It should have information applicable to all employees. You can put language in there, management directives, but the risk you run is then you have an employee, when you go to use the handbook and say you violated this policy, the employee turns and says, well, it says here that my manager should have done X, Y, and Z, and my manager never did that, so you don't enforce the policies against your own manager. The simple solution is have a separate document that you distribute only to your managers, whether you call it management directives or management policies or something like that, that all employees don't have in their hands. It's not a huge deal, and some employers do just include management directives, but when I'm reviewing a handbook and I see those, I always cringe, because I've been in depositions already where the savvy plaintiff's attorney is throwing that handbook in front of my client saying, well, it says here your managers were supposed to do this, that, and the other thing, and they never did that, did they? Well, I guess not. So you don't enforce your policies, do you? It just makes us look bad. And we can avoid that very simply by having a separate document that never gets in their hands. Internet postings and social media. This is a great example of where common sense, probably the most prominent example of where what I would say is common sense can get employers in big trouble. Now, I'll couch that by saying these legal requirements apply in the private sector, but they have companion requirements under the state law, which it's not clear that the state is as aggressive as the federal agencies are right now, but they still are generally applicable to you. And the situation is, you have an employee who on his or her Facebook page decides, posts about the district manager is a blankety blank, he doesn't know what he's doing, he doesn't pay us enough, other people got bigger raises, or no one's getting any raises, and then all of a sudden you got a bunch of people piling on, all complaining about the district, or maybe board members, or just, a real hot mess on a Facebook page. What's your initial reaction? Take action. We gotta fire that employer, or at least address it, we gotta put an end to that. Under the law, non-supervisory employees have the right to engage in concerted, protected activity with respect to terms and conditions of employment. It's the law that gives employees the rights to form unions. Because what is a union, after all? Employees who band together to discuss and then fight for terms and conditions of employment. And think about the things that unions can do. In most situations, they can strike, they can picket, they can they can be out front of your office, unfair labor practices, unfair wages. Unions can do a lot of stuff that can make your lives really miserable. All of those same rights apply to employees working in concert, whether they have a union or not. Employees have the right to talk to each other about their wages. They have a right to talk to each other and complain about their bosses or terms and conditions of employment. And where in the past that wasn't usually an issue was those conversations occurred around the water cooler or at the local watering hole after work, where they're complaining about work, so be it, but you're maybe not happy about it, but so be it. Now they can put up a website, IHateBlankCountyConservationDistrict.com, and they can advertise to the world what horrible people you are as employers. And now suddenly that can really affect you. That can affect a lot. It can make your lives miserable. It can really affect what you do. But the same protections apply, and those protections are extraordinarily broad. Much broader than common sense would otherwise indicate. And the way I would advise you to think about it, if a union can picket you and advertise that and put up websites and do all sorts of things, employees can do that without a union. And where that comes up is social media, and people want to nip that in the bud. And right now, the federal National Labor Relations Board, which applies to in the private sector, they are all over employers for this, because they are very aggressively pro-employee, which some might categorize as anti-employer, some being myself. But the reality is, employers put together these policies when social media started to become prevalent. Facebook, Twitter, even just putting up web pages. We've had clients where employees have put up web pages like trashing the client. I mean, search for Walmart web pages one day and look at all the horrible things people say about Walmart. A lot of times those are unions and employees. So employers have tried to address that, saying you can't go out and badmouth us in social media. That's protected. So for a social media policy, you got to be smart about that. And what I would say is, in any policy like that, remind employees that the same principles and guidelines that apply in your other policies apply equally to the use of social media. And that includes off-duty use, personal use. You can't harass people. You can't do other things that you're not allowed to do under our policies. Just because you're using social media doesn't mean you're allowed to do that. You can prohibit employees from using social media while at work unless it's for district business. Just like you can prohibit personal use of the internet and things like that. And that's one where, granted, I'm a dinosaur. I'm one of the few people on earth who doesn't have a Facebook page. But I don't really see the need for employees to be using social media at work for personal reasons. It's a personal opinion. You may say in our district we allow it, and that's fine. But I would be much more comfortable with prohibiting all personal use of social media than I would be all personal use of the internet, because that's not what I see as the reality in most workplaces. What you don't want to have in a policy like that is some broad prohibition on speaking negatively about the district or managers or coworkers or things like that. These policies are very, the policy that I use right now with employers, literally the NLRB, which has been so focused on this issue, I think a year or two ago issued a policy because they've been finding so many employers in violation. They actually distributed one. They said, we like this policy's okay. So I've been using that because this is such an unsettled area of the law. I've taken that policy, modified it a little bit, but where I can, word for word, using language that the NLRB is blessed, because no one knows where the line is between what you can prohibit and what you can't, and the more you prohibit, the more likely you are to get yourself in trouble. Drug and alcohol policies. A couple of thoughts. It's good to have a policy that prohibits numerous things related to work. No reporting to work under the influence of illegal drugs or alcohol, no possession of drugs or alcohol at work, things like that. I would also advise having a policy that provides for the potential drug or alcohol testing if the district has reasonable suspicion that someone is in violation of the policy. The reason why is, again, expectation of privacy. If you have a reasonable suspicion policy, you don't ever have to test anyone. But what I've had happen to me many times is a client calls me and says, we have an employee here, we really believe that he or she's under the influence, we want to send the person for a drug test. And my first question is, do you have a policy that provides for drug testing? If the answer is no, there is risk there sending that employee for a drug test, but we haven't put the employee on notice that we may do that. It's a privacy thing again. And it's easily fixable. We may test under these circumstances. We gave this handbook to you, we put you on notice, you have no reasonable expectation of privacy. Two points to just address briefly regarding drugs and alcohol. Marijuana. Increasingly, states across the nation have approved the medicinal use of marijuana. A couple states in the western half of the country, a couple, I think 2 at this point, have approved recreational use of marijuana. Now, none of those states are close to us, but since we don't do these seminars every year, I would not be shocked if before the next time we do seminars like this, some of our more closer states might have passed laws, at the very least permitting medicinal use of marijuana. The question then is, can we prohibit employees from using marijuana? When an employee takes a drug test for marijuana, unlike cocaine and opioids and other drugs like that, which typically flush out of the system, if you get a positive test, that means that person used that drug within the last 24 hours or so. Marijuana can stay in the system for a long time, so that if an employee uses marijuana on a Saturday and takes a drug test on a Wednesday, there's a good chance that employee is going to fail that drug test. And the question then becomes, well, if marijuana is now legal under state law, can we still take action? And the answer to that question is absolutely yes. Federal law still prohibits marijuana, under marijuana use. Under federal law, marijuana is an illegal drug. So just because a state may say we're going to allow it, and just because the current federal government may say we will look the other way, federal law prohibits use of marijuana. So if you as an employer want to prohibit employees from using marijuana, you absolutely can do so, even if they say, well, I have a legal right to use it now. I mean, hypothetically speaking, you have an employee who has a place in Colorado and goes to Colorado every weekend where marijuana is now legal. And that employee comes back, you test that employee positive for marijuana, you absolutely can take disciplinary action on that basis. Courts in Colorado have held that. You hear a lot about marijuana. I think you're only going to hear more as the state laws change. Just keep that in mind. Unless and until all the laws change, or all the laws that apply to us, federal and state, we can still prohibit the use of marijuana. Legal drugs. What I mean by legal drugs is over-the-counter drugs or prescribed drugs that are being used consistent with a prescription. What if we know, or what about employees maybe taking an opioid painkiller, Percocet or something like that? We don't want them driving one of our vehicles. We don't want, obviously there's safety concerns there. So can we have a policy that requires any employee taking a certain type of medication to report that to us? The answer is absolutely not. And this is where I give the caveat, don't shoot the messenger. These aren't my laws, these aren't my interpretations, I'm just the messenger delivering them. And perhaps that applies with no more force than here, because I think this is frankly crazy what the law currently says. But because of the protections given under the Americans with Disabilities Act for use for employees' medical conditions and use of prescription drugs, basically what you can require as an employer, you can tell employees that if you are using a prescribed or over-the-counter medication that is advertised or has commonly known side effects that may affect your ability to perform the job safely, you must obtain a note from your doctor or pharmacist certifying that you can do the job safely. And you take that note and you don't give it to us. You keep it. And then if we approach you one day and say, you're staggering around, what's going on? That's when you whip out the note and show it to us. That's all you can do. And frankly, you know, most people would say, that's crazy. If you knew an employee's taking Percocet or taking some sort of, you know, really powerful painkiller and getting behind the wheel and driving for the district, you know, now if you know about it and you've got concerns, I would address it. But you can't be proactive about it. You can't require employees in those situations to report that. And the EEOC has gone so far in giving an opinion on a matter involving city bus drivers, where a city wanted to impose such a requirement because they didn't want people driving their buses who were under the influence of these medications. What the EEOC has recognized, the only types of jobs where you can have a prospective requirement that employees have to tell you when they start taking this kind of stuff: airline pilots, police, and firefighters. And when a city said, well, what about our bus drivers? The EEOC said, well, an airline disaster has the potential to kill hundreds of people. A bus crash would only kill about 50, so you know that's where we're going to draw the line. And I am paraphrasing, but that is really, without exaggeration, where the line was drawn. So, you know, your city bus driver may be taking some sort of very powerful pain medication and really be in a scary situation. And the EEOC's position is the employer's not allowed to ask about that unless they have information in front of them that on an individualized basis would lead them to approach the employee. If an employer knows an employee may pose a direct threat to himself, herself, or others, then you can confront an employee and say, look, we need more medical information. We need to make sure that you're okay to do this. But you can't put policies in place that require employees first to come forward and disclose that unless they're flying planes or firefighters or police officers. Again, not my laws, just telling you like it is. Improper pay deduction policy. That is a boilerplate legal language law that dates back to 2004. Basically what it says is for your salaried exempt employees, which we're going to talk about in detail here in a few minutes, you can have a policy in place that prohibits, that basically allows deductions from a salaried exempt employee's salary only for the certain reasons permitted by law, and if an employee believes that an improper deduction has been made, report it, we'll address it. The purpose of the policy is before the 2004 regulations came out, if you made an improper deduction from a salaried exempt employee's salary, that salaried exempt employee would then become non-exempt, meaning you owed them on an overtime compensation, and anyone else who holds that position may also now be non-exempt because you're not treating them as exempt and paying them on a salary basis. So it's a great policy to have because it frankly is not implicated very often. It really means it doesn't hurt you or cause you any grief. It just provides you protection in case something goes wrong. And with that, leading into section 3 on page 26, the wage and hour laws. Another area, common sense will not ensure compliance. The wage and hour laws are the laws that govern how we pay employees. The Fair Labor Standards Act, which applies to all public, for our purposes, all public sector employers in addition to most private sector employers. That's the law that gives employees the right to receive minimum wage for hours worked, overtime compensation unless they're otherwise exempt. It also has child labor law restrictions in that law and record-keeping requirements. The Pennsylvania Minimum Wage Act is the companion state law that in many ways mirrors the FLSA and is similar but not identical in certain areas. But that law also applies to all employers in Pennsylvania, and that's what governs overtime, minimum wage, and record keeping. Equal Pay Act is the wage and hour law that requires equal pay for equal work across gender. It doesn't allow gender discrimination in pay unless the different pay is based upon some factor other than gender. And then the other wage and hour law, the main one that we deal with, Pennsylvania Wage Payment and Collection Law, and that's on page 29 of your materials. This law has a number of components to it, and it's an important law because employers commonly make mistakes under this law that potentially can cause grief later. This law really doesn't create any statutory right to wages. This law creates requirements on paying the wages to employees that you tell them you're going to pay them. And what I mean by that is, this is the law that requires all employers to set a regular pay date. That's why we don't pay people some days on Wednesdays, some weeks on Thursdays. You got to set a regular pay date. You have to be regular about that. Wage deductions on page 30 of the materials. And this is for any employee, exempt or non-exempt, any employee. We can deduct from the wages earned by the employee for only those reasons listed on pages 30 and 31. And a lot of them are obvious and self-evident. They talk about provided by law, such as, Social Security, Medicare, things like that. There's a catch-all at the end of these regulations that allow other deductions authorized in writing by employees and as deemed proper by the Pennsylvania Department of Labor and Industry. Two things here. One, any deduction not otherwise on this list has to be authorized by the employee in writing. And what I mean by that is, say you have a vacation or paid leave policy that allows employees to use vacation before they earn it, meaning you earn your vacation in 2014, you accrue, 3 days a month. So each three, you earn, basically 1/12 of your vacation allotment for the year each month. But we're not going to make you take it only once you earn it, because then everyone will take vacation in December, because you're going to earn 3 more days in December. So we say you can use your vacation any point during the year, but you accrue it month by month. So then you have an employee who maybe gets 3 weeks total of vacation for the year, takes 2 weeks of vacation in January and quits on January 15th. Well, that employee took vacation that he or she did not earn. Well, okay, we'll just deduct that out of the final paycheck. You can do that if you have the employee's authorization to do so in writing. So that's why if you have a policy like that, you should have the employee sign something. It could be at the start of employment. It doesn't have to be every time they use vacation, but just makes clear. Under our vacation policy, we allow you to use vacation before you earn it, per the terms of the policy. If you have a negative vacation balance at the end of your employment, we will deduct that balance from your final paycheck. Yes?
If that's, we have that in the personnel manual written that way, and all the personnel manuals are signed off, does that count?
Yes. I've never seen the Department of Labor and Industry take the position that it does. And I think for a situation like that, yes. If you have that in your policy and then have the employee sign an acknowledgement of the handbook where that policy is found, you should be fine. So a deduction not listed here has to be authorized in writing, but not all not all deductions authorized in writing are legal. And what I mean by that, the law says, the Wage Payment Collection Law says deductions have to be for the convenience of the employee. So what does that mean? Okay, you've got maybe you give equipment, district equipment, maybe a district laptop to an employee, and you're very much on the ball, so you're going to have employees sign forms when they get equipment. You have to return this equipment when you leave, when your employment with the district ends, and if you don't, we'll deduct the cost of the equipment out of your final paycheck. We got it in writing, we should be good to go. I would say no, and the reason why, again, remember what I said, common sense doesn't carry the day. Wait, they stole our laptop, why can't I take it out of their final paycheck? I mean, they got something I want, I got something they want. Why? Why not? The deductions have to be for the convenience of the employee. We need to somehow be able to argue that this deduction is really for the employee's benefit. The vacation deduction, I think we can argue, because the benefit is using your vacation before you earn it. That's all we can say. That's why all we're doing is squaring up here. The law is very sensitive to employers either charging employees for broken equipment or something like that. A lot of employers want to do that. Oh, you broke our laptop by leaving on the back of the Explorer, and you pulled out and it fell off the top and you shattered the laptop. Well, you're an idiot, and we're not paying for that. You got to pay us. I don't like that, and the reason why is the paycheck is sacred under the law. The law recognizes the power of the paycheck. Virtually all of us are here and do what we do for the paycheck. Now, some people work out of the goodness of their own hearts and don't even care about getting paid. That's great. Full disclosure, I'm not one of them. That's just the way it is. The paycheck is why people work. And if employers can monkey around with that paycheck and use it in different ways to say, yeah, we'll pay you this money, but you break any of our equipment, we're going to take it out of your paycheck. Well, that pen has a little less ink in it than it started at the beginning of the day, so I'm going to deduct that out of your paycheck. You can quickly see how things can get out of control, and that paycheck can go from full size to very small. Now, we would never do that, but as many of these wage and hour laws, they're designed to close loopholes. They're designed to address abuse, but the effect goes well beyond that abuse, and this is one area. You can't, I would not deduct from an employee's paycheck for lost, broken, stolen, even unreturned equipment. What would the law say you do? You give the paycheck, and you have to pay that under this. That paycheck must be paid no later than the next regularly scheduled pay date. Give the paycheck, and then go after them. Whether that's through filing a complaint with the district justice from a civil perspective, if it's something significant, I don't know, calling law enforcement, I don't know, but the paycheck's not in play. And that's something that a lot of employers don't get because, again, common sense would indicate, or you say to an employee, you got my laptop, I got your paycheck. You bring the laptop, I'll give you your paycheck. Makes sense to me. Not allowed to do it. This part right here, must pay by the next regularly scheduled pay date. And a lot of employers that I deal with, they don't do that, and that's problematic. And why is it problem? Okay, then if somebody files a complaint, I'll give them the paycheck, then they'll leave me alone. Well, there are penalties involved for non-compliance with the wage payment collection law, and also that law is a fee-shifting one, meaning if somebody brings a claim against you and has a lawyer, if that person wins, you have to pay that employee's legal fees. So if you win, so that it really adds to the potential risk there. Without that hammer, a lot of employers would say, whatever, I'm not going to do any of this. Call me on it, then I'll pay you. And not surprisingly, the law is designed in a way to eliminate that option. Another thing that's important, these laws are not waivable. Well, I had an employee sign a form saying this was okay. Does not. The Wage Payment Collection Law is not waivable, and the Fair Labor Standards Act and Pennsylvania Minimum Wage Act are not waivable. What does that mean? $7.25 is the current minimum wage here in the Commonwealth. Well, I'll just have the employee sign a form saying he agrees to work for $6 an hour. You can't have, and you can put all the legalese, legal gobbledygook you want to put in there. It's not going to matter. You can't waive the right to collect minimum wage. You can't waive these rights as an employee. That basically we have to comply or else. Direct deposit. Another commonly, I wouldn't say misunderstood, but do any of you, your districts or your counties mandate the use of direct deposit? Okay, we got one there. Increasingly we see that a lot because cutting paychecks, there's a cost associated with it. It's cheaper and easier to do it via direct deposit. What the law says is that we can pay via direct deposit basically if we have something in writing from the employee authorizing us to do so. So what if we tell employees we're phasing out paychecks, everyone has to now be paid via direct deposit? What if we have an employee who says no? Well, playing this out, we can only do direct deposit with the employee's written authorization, which leaves us two choices: to cut a paycheck or to fire the employee. We can't force someone to use direct deposit. Now, that said, a lot of employers do force people to use direct deposit, meaning we mandate direct deposit. Is it unlawful to have such a policy? It's not. But what you need to keep in mind here is employees have a right to wages. We can't not pay them, and we can only direct deposit if they authorize it. So if they truly refuse, either you got to pay them or you got to fire them. And what I say to employers when they ask me, can I implement this policy, I answer their question with a question, which is, are you prepared to fire people who refuse to be paid via direct deposit? If the answer is yes, I don't know, I'm not aware of anything under the law that would prohibit an employer from firing an otherwise good employee because the employee wouldn't agree to direct deposit. I think you can, but the more pertinent question is, do you really want to fire good employees over a situation like this? What I've seen many employers do is have a policy that mandates direct deposit, but then if an employee calls our bluff, just find a way to cut the check and just keep the employee. And it's easier to enforce or to have such a policy for new hires. That's where when somebody's really looking for a job and want to get their foot in the door and I'm ready to come work there, they're much more likely to say, okay, direct deposit, where do I sign? Good enough. It's when you try to midstream enforce such a policy with your current employees, there might be some bumps in the road. So, pay cards, just before we leave direct deposit, I don't know if any of you have ever heard of this concept of pay cards, again, since it's just starting to happen now more and more, and if we do these seminars again in the future, this may grow in the interim, but basically it's a debit card where employers pay employees by putting funds onto their debit card. It's convenient for employers, it's it's the hot new thing. But like with many hot new things in the employment law world, the law doesn't address it. The law doesn't permit it necessarily. You can use pay cards if employees voluntarily agree to it, but there was a lawsuit filed in Luzerne County a couple of months ago against a McDonald's franchisee who was basically allegedly telling its employees, I'm only paying via pay card. So here's your check, but it's not a check, it's a card. And those employees alleged that there were fees associated with the card, so that the wages weren't free and clear if they didn't do certain things. So, you know, if you ever have somebody trying to sell you on the use of pay cards, they're not unlawful necessarily, but I would only advise them where it's an option you give to your employees, not something you say, starting tomorrow, we're paying you all on this debit card, at least until the law catches up and says we can't. The exemptions to the Fair Labor Standards Act and Pennsylvania Minimum Wage Act on pages 32 and onward. Exemptions are, they're basically the exceptions to the overtime and minimum wage requirement. For many of you here, you're likely considered exempt by your districts, like the managers as such. You receive a guaranteed salary, you don't receive extra compensation for hours worked in excess of 40 in any work week. That's an exempt employee. Because there are no industry-specific exemptions that apply to conservation districts, the only potential exemptions we have available to us are what's referred to as the white-collar exemptions. They are generally applicable, meaning no matter the employer, if an employee qualifies for one of the white-collar exemptions, he or she is exempt. Now, there are a lot of misconceptions associated with the overtime exemptions under these laws, starting with how they work. Everyone is either exempt or non-exempt. However, the default status is non-exempt. You could pay everyone at your district, from the manager on down, an hourly wage and overtime in excess of 40 hours in any work week and be perfectly lawful and fine. The CEO of Microsoft could be paid on an hourly basis, and that would be absolutely fine. To treat an employee as exempt, an employer may do so only if the employer can show that the employee clearly falls within one of the established exemptions. The burden is on the employer to prove that the employee falls within that, meets the test essentially. The presumption is that folks are generally non-exempt. Close calls go against employers. So it's not like exempt and non-exempt were not created equally. Non-exempt is the default, exempt is something special, it's unusual. And a lot of employers don't look at it that way. I hear, well, I just pay my office people salaries, so that means I'm fine, right? Nope. The white collar exemptions have two parts to their test. One is the salary basis component. Every one of these white collar exemptions, an employee must be paid a guaranteed salary of at least $455 per week. That number isn't really relevant, it's so low that that usually isn't an issue. Where this becomes an issue is what salary means. It means you get paid the guaranteed set salary in any week in which that person performs any work at all, unless one of the permissible deductions would apply, and those deductions are listed on pages 34 and 35 for you. So, you know, you have, for example, you have an exempt salaried employee who decides, you know what, I'm leaving at noon today to go get a haircut, I'm not coming back. And you as the manager say, no, you need to work today, you have no paid leave left available to you, you burned through all that, you're not leaving at noon, and then the employee leaves anyway. Well, then I'm going to dock that employee a half-day pay. Can't do that. You can only deduct for absences caused by personal reasons, such as really anything other than sickness or illness, sickness or disability, only if the absence is on a day or more basis. Partial day absences, you can't make a deduction. What can you do? Write that employee up, fire that employee, discipline the employee for insubordination, but you can't deduct from the salary. The salary must be paid in full every week unless one of those bullet-pointed deduction rules applies. Now that said, what if that same employee had some paid leave still available to him or her? You can absolutely deduct from the paid leave balance, saying, oh, you had a day and a half of paid time off left, well now you have a day left because I deducted a half day PTO from you. Why is that permitted? Because at the end of the week, the employee still receives the full salary. The only thing that changed is the amount of paid time off the employee had available to him or her. These laws don't address paid time off, they address the salary at the end of the week. And that's why, as long as the salary is the same, you can make a deduction for a partial day absence. But even if you qualify, even if you feel comfortable that we treat these folks, we pay them on a salary basis, and we meet the requirement for that, that's only half the test, and it's frankly the easier of the two halves to meet. The other half is proving that the employee's duties meet one of the duties tests associated with these exemptions, and those are laid out for you starting on page 36. The executive exemption applies for an employee, and for all of them must meet this minimum salary requirement. The primary duty must be managing the enterprise or managing a customarily recognized department or subdivision of the enterprise. The employee must customarily and regularly direct the work of at least 2 or more full-time employees or their equivalents. And the employee must have the authority to hire or fire other employees, or the employee's suggestions and recommendations as to hiring, firing, advancement, promotion, etc. must be given particular weight. For those of you who are district managers, this is why you're exempt, under the executive exemption. But where this gets misapplied by employers is either you have someone who does not supervise 2 or more full-time employees, and you really want to look at the corporate or the district hierarchy of, the district manager's here, and then the following people report to the district manager reports to the board. If you've got an exempt executive, you want to make sure there's 2 lines, and there's at least 2 lines going down. If you have a manager who only supervises 1 employee, he or she cannot be exempt because you have to supervise 2 or more full-time employees. And then with respect to the hire and fire component, really there you just need to make sure that the folks who qualify for this exemption have some level of real input in such decisions. Now maybe your board needs to sign off on hiring and firing decisions, that's fine, as long as the board gives your recommendations particular weight. What does particular weight mean? I have no idea. It's just a nice empty legal phrase. But what I would just say is, use common sense here. I mean, as long as there's some role being played, where employers get in trouble is they have supervisors that they treat as exempt and they play no role whatsoever in this process. They don't hire people, maybe they don't even discipline, sort of like the working supervisor. That's where they would not meet this exemption. The administrative exemption is perhaps the most commonly misapplied exemption, and that is because people see administrative and they think, oh, anyone who's basically an office employee qualifies for this exemption. And that's not true. This exemption, applies only to high-level administrators. The test there is on page 37. They need to perform office or non-manual work directly related to management operations, sounds like office work, and they must exercise discretion and independent judgment with respect to matters of significance in the performance of these duties. That means real discretion and independent judgment. If not decision makers, they are winnowing down the choices and making recommendations perhaps to the ultimate decision makers. These are high-level administrators. They're not receptionists, administrative assistants, things like that, positions like that, because they simply would not exercise the discretion and independent judgment to qualify for the exemption. So, if you have an employee who's performing generally routine clerical duties and you treat that employee as exempt, the question I will always ask in that situation is how many hours a week does that employee work? If the answer is every single week that employee works no more than 35 hours or 37.5 hours, if you can keep relatively accurate records to confirm that, you're okay. The exemption, non-exemption test, that really is only relevant to the extent the employee works overtime, meaning more than 40 hours in a week, or is somehow not paid at least the minimum wage, which I don't think really comes up very often. So it's really only relevant if that employee is working more than 40 hours. If that employee is, then you potentially have an issue. But if the employee's not, what I would say is keep paying the employee the salary, just track the hours worked and make sure they never work more than 40. If they don't, how you classify them is irrelevant, quite frankly. But if they are working more than 40, we have an issue. So when you think about the folks you treat as exempt, keep in mind how high the bar is for the administrative exemption. The professional exemption, as discussed on page 38 and 39, that's the exemption that applies to individuals with specialized post-high school degrees, basically, and a job that requires such a degree. It's your learned professionals, as it's referred to. This is the exemption that covers your lawyers, your doctors, your teachers. It could also apply to engineers, or a number. You all may have employees who might meet this exemption. But the keys with this exemption, while there is a requirement that the employee perform work requiring the consistent exercise of discretion and judgment, it's a lower bar than the administrative exemption, and most jobs that require that higher education are going to meet that. This usually turns on the educational requirements. If you say we are only gonna hire technicians who have a 4-year degree in one of the following earth science fields, or higher, that's fine. We're pretty much home free. But if we're gonna hire folks who have 4-year philosophy degrees and basket weaving degrees and things like that for a position, even if it's a 4-year degree, that's not specialized. So that would be a problem. Unless they all then had a master's degree in, geology or whatever the appropriate, whatever the appropriate field might be. So you want to look at what do we require. If we don't require a 4-year degree or more, or we don't require a specialized 4-year degree, we're probably going to have a hard time showing that that individual meets the exemption. And this particularly can become a problem when you're hiring, because degrees are wonderful and all, but we all know that real life experience is a lot more important than a degree. And you may get somebody with perhaps a 2-year degree or a non-specialized 4-year degree who has fantastic experience and is exactly what you're looking for, but the job says you gotta have a 4-year degree in one of the following fields. In that situation, hiring that person could jeopardize, I say could, because the law frankly is very unclear here. The current test talks about the work, basically the advanced knowledge associated with the job must be customarily acquired by a prolonged course of specialized intellectual instruction. It doesn't say it has to be. Customarily, and actually the regulations recognize that experience in certain circumstances may meet that requirement. Problem we have is this exemption test was written by the Bush administration, U.S. Department of Labor. Under the current administration, the approach and philosophy and view of these things are very, very different. And I would not feel comfortable as an employer applying this exemption to somebody if we have folks in that job classification who don't have specialized 4-year degrees. Or if the job says we require either a 4-year degree or similar experience or something like that. Because there's an argument there that that's not a learned professional. It's very gray, it's unclear. I wish I could give you better guidance on to what extent that this would apply, but just be aware that when you look at this, that if you have folks that you're treating as exempt, it's best if you require for that job a specialized 4-year degree. One of the ways I've seen districts work around that is if you have a specific position, and maybe your higher level folks all have that 4-year degree, but the same position you have lower level folks who don't, break that position down into levels. If you can say like, a level 1 tech, we allow experience or a 2-year degree. Level 2, you gotta have the 4-year degree. Then we can treat the level 2 folks as exempt and the level 1 folks as non-exempt. It's one of the ways to work around that if that's, if that's something that would be operationally feasible at your district if you have this issue. Computer-related professionals, this is your IT folks. I'm not going to get into that too much. But again, it's your high-level IT folks. The things to keep in mind about this, I mentioned about the current administration. These laws, in the eyes of the current administration, and I have a hard time disagreeing, are some of the most violated laws in the employment sector. Folks don't understand how this works. And in the eyes of the current Department of Labor, not enough people are getting overtime compensation that are entitled to it. So this is something to really closely scrutinize and think about making changes if you think you have risk, because this is not a friendly environment currently for employers, because frankly a lot of employers get this wrong. It's a high bar to meet. People don't understand that, and these are employee protection laws in the eyes of the Department of Labor. So if we're not paying somebody overtime who arguably is entitled to it, it is viewed that we're victimizing that employee. And you may say, well, I'm paying you a salary, but that salary is with the expectation it's a 45-hour-a-week job. Under Pennsylvania law, the damages, that salary divided by 40, and then an additional time and a half for all hours over 40. And you may be saying, well, no, the salary is never designed for 40 hours, it's designed for 45. It's a windfall for employees if we screw this up, because the recognition is simply, that what we meant, the law is going to say, well, you violated, we don't care what you meant. We're going to make you pay time and a half now on that amount to come up with what the regular rate would be for unpaid overtime work. The other thing to keep in mind, these laws require that we keep accurate hours worked records for all non-exempt employees. If we misclassify someone, we might not be keeping their hours worked records. And if we're not, what does that mean? Well, not only do we have an independent violation of these laws, so the employee says, I worked 70 hours a week and never got overtime. And we know that's complete garbage. But what evidence do we have? We basically have to go to court and say, Your Honor, we don't have the evidence the law requires us to keep, but just trust us, he or she didn't work 70 hours. In many cases, the employee wins on that. So these claims can get very expensive very quickly. It is a very hostile environment currently for employers in this area, and it's an important area to keep your eye on. Now, along the same lines, independent contractors at the bottom of page 41. This is a huge current issue for employers, and that is an independent contractor is essentially anyone who performs services for your district that you do not treat as an employee. Could be a consultant, could be, a lot of different terms are given. But under the law, everyone's either an employee or an other. And independent contractors are an other. And the laws don't apply to independent contractors. All of the employment laws don't. They're not entitled to unemployment compensation. They're not covered by the workers' compensation laws. They can't file discrimination claims. They have no entitlement to overtime or minimum wage. If you're a true independent contractor, you have no protections under any of these laws. Well, not surprisingly, you also get no taxes withheld from the pay. So no Social Security, no Medicare. Uncle Sam's not getting his cut of the relationship. So basically, the courts and Congress and government agencies that enforce these laws realize independent contractor status is a huge windfall for employers. And because of that, if it was easy to make consider someone an independent contractor and treat them in that way, we all would be independent contractors, believe me. Because we would all save money ourselves, our employers wouldn't have to pay payroll taxes on us, they wouldn't be covered by any of these laws. So the reality is, to establish independent contractor status under the law is actually very difficult. And many employers treat folks as independent contractors who should be treated under the law as employees. So what does that mean? That employer now has unpaid tax liabilities, has some problems with the IRS because we never pay payroll taxes for any of these individuals, no workers' comp insurance, which actually is a criminal offense. If you have an employee who gets injured, or you have someone who gets injured, no workers' comp, and it's deemed that that person's your employee, that's a criminal offense. These are perhaps the most significant risks that employers face, because if you violate this, you don't violate one law, you violate almost all of them. And it is such a wonderful incentive to have someone be an independent contractor. It's dangerous. So what does that mean for us? Well, what is a true independent contractor? I gave the example on Tuesday. I'll give a different one on Thursday, because we're having a lot of work done at our house right now, and at least I find out when I get home. My driveway is being sealed today. On Tuesday, my shutters are being painted, but today at my house, my driveway is being sealed. We called someone up out of the Yellow Pages. They came out, they gave us an estimate. We engaged them. They come out in one day. They bring all their own equipment. They seal the driveway. I'm not there to supervise. I'm going to come home and see that little tape across the driveway and stay off it for a couple days. I get a bill in the mail. I pay the bill. End of the day. Done. The driveway sealers are not my employees. They are independent contractors. They don't rely on me for their economic support. I'm one of many customers. They provide their own tools, equipment, materials. I'm not supervising the work. With an independent contractor, all you care about is the end result. But with employees, we don't just judge employees on the end result. We supervise their day-to-day work. That's the oversight provided in supervision. The driveway sealers have a special skill. I guess I could figure out how to seal my driveway, but I've never done it, and I'd probably scald myself if I tried, and it would be a disaster. So they have a special skill. It's a temporary working relationship. One day at my house, they'll get the job done, and that service is not an integral part of my life. They perform a service for me, I pay them for that service. That's an independent contractor. Now, let's say, it's not a perfect analogy, but plumbers. A plumber's an independent contractor. You call a plumber to fix your pipes, independent contractor. Now, say I own an apartment complex, and I have a plumber, and that plumber is working on my apartments 35 weeks out of the year, 30 hours a week. I provide the tools. I tell that plumber, today you're in unit 5A, and then tomorrow it's 6B, and do this, and then do that, and do that over there. That's starting to look a lot more like my employee. And that's really how this works. The best guidance, all the fancy legal tests they have, if it walks, talks, and acts like an employee, it usually is. And my driveway sealer, there's nothing about that relationship other than me giving that person money that looks like employment. Everything else doesn't. But the more something looks like employment, the more likely it is. So when you think about if you engage any consultants and you come to me and say, what do you think of this? The question I'm going to ask is, what's the duration of the relationship? Is it a 1-week assignment or is it 2 years? If it's 2 years, that's looking a lot more like an employee. Who's providing the equipment, tools, materials used by the consultant? Are they working on our computers or are they using their own stuff? Are they working at our offices or are they working remotely? That's a factor that matters. Is there a specialized skill involved? Is the consultant a blank and you need a blank to perform this service for the district? That would help. How are we compensating that consultant? Opportunity for profit or loss depending upon his managerial skill. The test there is on page 42 for you. If we're being billed for the project, that's better. Because if that person's efficient and smart and skilled and experienced, they might be able to get it done more quickly than someone who's otherwise not. So there's an opportunity for profit or loss there. If we're being billed by the hour, that does not appear to be, that looks a lot more like an employment relationship. The bottom line is there are currently joint enforcement initiatives by the Department of Labor and the IRS. This is, Senator Casey just issued another bill in the Senate a couple of months ago on independent contractor misclassification. This is perhaps the hottest area in employment law where folks are really going after this because it's such a windfall for employers. I mean, we know we're not making a windfall off of it, but it's so ripe for abuse, even when we're not abusing it. And quite frankly, it's depriving Uncle Sam of tax revenue, which is always a quick way to get Uncle Sam to start coming after you. So to the extent that your district engages any consultants or anyone that you don't treat as an employee, look at the factors we list on page 42. How comfortable are you with that? Because at the end of the day, the prospective fix here is actually pretty easy. Just call them a temporary employee, set up a payment arrangement that meets these legal requirements we're talking about. They're covered under your workers' comp. You're fine. It's as simple as that. I mean, it doesn't fundamentally change the relationship in a lot of these situations. Now, you may have less cost certainty, you got to track hours, it may be more of a pain, but there's ways to do this in many situations that aren't, that if you ever got called on this, you would sit there and kick yourself saying, oh, 2 years ago, why didn't I just pay this person $10 an hour and withhold taxes and avoid this whole grief?
Do they have to meet all those requirements or just some of them?
Well, they don't have to meet all of them. Those are relevant factors in the analysis. It's a multi-factor test, meaning there's no bright line rule that says you have to be A, B, and C. Those are just, and that's why I said the whole if it walks, talks, and looks like an employee. There's the extreme examples of my driveway sealer and an employee, which we know what an employee is. Then there's a huge spectrum in between of where folks fall. And the closer on that spectrum one falls to independent contractor, the better you are. But the closer they are to employee, the worse you are. So think of that sort of as a spectrum. If you've got 3 factors in your favor and 3 not, there's risk there. Because you're pretty much smack dab in the middle. And as I say there, the courts apply a very narrow definition of independent contractor. But if you say pretty much all the factors except for 1 point to independent contractor status, you're probably okay. It's really, unfortunately, it's not any clearer than that. Now, that's exempt employees and independent contractors. What about non-exempt employees? And non-exempt may sound like kind of a foreign word that you're less familiar with. These are generally referred to as salary. Oh, yes, Janet.
Can I go back to the consultant? Who is it that busts you if you have a consultant that really should be an employee? Is it the consultant himself? Is it the IRS? I mean, who is it that?
It could be any. The question was who busts you if you have a consultant that's misclassified. It really can be any, all of the above. Again, this is another set of laws that's not waivable. So you may have a written independent contractor agreement and have that same person turn around and go sue you in court and say, you didn't treat me right, and we can't use, the independent contract agreement's helpful, but it's not dispositive. More often than not, where it's really parallel tracks. They're either complaint driven, where folks can either go to the Department of Labor or they can go straight to court and sue over these issues for Fair Labor Standards Act violations. But the DOL and IRS also do audits and things like that, so there might not even be a complaint. They may come in and just say, do you engage anyone you call as an independent contractor? Yes, we need information on that. So, you know, that's one of the things that's probably most bitter about this for employers is, look, he's an adult, we're adults, our cards were on the table, everybody knew this was an independent contractor relationship, and he's fine with it, and I'm still getting, you know, audited by the federal government and be given a hard time.
I think most times that's what happens,
Yeah.
is an audit happens, and that's how it comes to.
Is it even worse if you have this independent contractor under contract and don't bid it out? It's like he's the only person, they are the only entity you've ever went to for this contract. It's a long-ish contract. Does that make it even look even worse?
Yeah, the longer duration of the contract is definitely a bad factor. It's one of the worst factors, I would say, because typically employment is usually much more long-term than my driveway CO. That's an extreme example, but he'll be there for 2 hours at my house today. You know, it's a 2-hour relationship. If it's a 18-month relationship, that's not a typical independent contractor relationship. Now, whether you bid it out to others or just use one independent contractor, I guess it technically helps to use different folks, but that's less of an important factor in my mind because it's still the nature of the work. We need this work done on a daily basis, and whether one person or 10 people are doing it over the course of 2 years, that's the kind of, usually the best situations for independent contractors are short-term, temporary, we have a problem, come fix it. Or the other example I often use is like people who clean your offices. You engage a cleaning company to come out and they're there every day and it's a long-term relationship, but clearly it's an independent contractor one. We're not supervising, they're bringing their own vacuums, we're just coming in and just want to make sure that the garbage cans are emptied every day. So, unfortunately it's very mushy. That you can have situations where one factor is important and other situations it's not. But to your example, I think if it's something that's regularly ongoing, I always start with, why don't we just treat them like an employee? What's so bad about that?
Does the issue go away if they have another contract with somebody else too? At
Yes,
the same time, that goes away, even if it's an hour a week or 2 hours?
that helps. That's a good factor. The question was, what if they have contracts with more than just you, if they perform the same services for others? That's actually a very important factor because typically employees don't moonlight, most employees don't, but typically independent contractors do. And when you have somebody, the test is called the economic reality test, and a lot of times it's looked at the economic dependence. When somebody's dependent solely on you for their livelihood for a prolonged period of time, that looks really like employment. However, if you are one of 10 clients or customers that contractor has, that looks a lot more like an independent contractor. So that is a big factor. And I always look at the amount of time spent, not just because it's a factor that helps employee versus independent contractor, but also to assess the potential risk. If somebody's performing services for you 2 hours a week, the risk there is the unpaid taxes are like, it's a relatively small amount of risk. If they're performing those services for you 45 hours a week, that risk is exponentially higher and also looks a lot more like an employment relationship in many situations.
What if it's based on a grant? So you get a grant to do a study. So you want to hire somebody, you want to have an independent contractor, a person call themselves an independent contractor, complete that study for you, knowing that at the end of this certain period, your grant's going to go away, the funds are going to go away, that's it.
Yeah,
Is that?
the question was, what if it's pursuant to complete a study pursuant to a grant? Really, the answer to that is going to come down to the individual facts of the situation. And I can best answer it by giving examples. If the grant calls for a study and you pick up the yellow pages and call up a business that engages in those studies and you engage that business to go do the study for you, you're probably okay. But if it's a one-person kind of thing and that person spends 6 to 8 or 9 or 12 months working full-time engaging in the study, and obviously there's more facts that would be relevant, but that looks more like employment. So it really comes down to the particulars. And what I would say is prospectively, if you think that there's some concern there, that it's not clearly on the independent contractor side, think about, can we make this work by treating this person as an employee? There's nothing wrong with having temporary employees, where you give a letter to someone saying, we're engaging you to complete the study for us, it's pursuant to the following grant. The time period is X to Y. You're at will, meaning we can still terminate it before the end of that, but it's a short-term project, withhold taxes, pay them like an employee. There's nothing wrong with doing that. It's like non-exempt status. You can't go wrong treating someone like an exempt, as an employee. You can only go wrong if you treat them as an independent contractor and they don't meet the test.
Tough thing is, once you hire them as an employee, then you have benefits. You have the healthcare, retirement, and that adds a lot of extra cost.
Not necessarily, it doesn't have to be. What I would say to that is, you define who's eligible for your benefits. And many employers have categories that say full-time, part-time, temporary, and temporary employees are not eligible for benefits. The only area where that's different, potentially one day, is under the Affordable Care Act with the employer mandate, but that hasn't kicked in yet. And if you're an independent district, it wouldn't even apply to you anyway, as the employer mandate only applies to larger employers. So you can say to somebody, the only right that employees have to paid leave, health insurance, or things like that are the rights pursuant to your policies that you create. And if your policies say that temporary employees are not eligible for benefits, you're allowed to do that and structure it in that manner. And that's why I always go back to, it's really, if you really dig into it, you might be able to easily accomplish the same thing you want to accomplish just by withholding taxes in that and avoid this whole potential landmine. Because you don't have to give them health insurance if you don't want to. If you want to, great. But especially if the work required is a couple hours a week, that sort of thing. You wouldn't give somebody who works a couple hours a week for your health insurance benefits anyway, probably. So you just say, we'll pay you $15 an hour, or whatever the case may be. We expect you to work 4 to 6 hours a week doing this. Many people would say, well, why don't I just do it as an independent contractor? The contrarian of you would say, well, why don't you just do it as an employee? It's virtually the same thing, and then you don't have to worry about this. I mean, every situation's different. It's not always that easy, but I wouldn't necessarily feel locked in by the benefits piece. You can revise your policies and create that category for temp employees. But where you can really do whatever you want there. What I would say though is, if this is going to be a 40-hour-a-week job for 18 months, to call it a temp job, I mean, you maybe can get around doing that, but that gets a little harder in the reality of just this person's going to say, why am I not getting benefits? So it's not necessarily that easy, but it's certainly an option.
If we enter into a contract with a consulting firm,
Mhm.
okay, their engineer or whatever licensed professional will be working on the project is being paid through them, and taxes are being withheld through that consulting firm.
Yep.
Why would I hire them as a temporary employee?
Well, you wouldn't, and that's the whole. When you engage business to business or employer to employer, that's much more like independent contractor status. You're much safer there. Where employers create the risk is where you hire one person as an independent contractor or consultant. No, when you my driveway seal, that's some company. It may just be 2 people, but it's a company. I engaged a business to perform a service for me, and that's one of the best factors in your favor. It's just that situation doesn't walk or talk like an employee, even if only one person's doing the job for the district in that situation. You're still contracting with a real company.
I'm saying like in my contract with XYZ Excavating, who comes in to do a stabilization project on a stream bank, and
Yep.
it might take them a week to do it.
That's, I think, a clear independent contractor situation. That's like my driveway sealer. But,
But you may have to go out to that job site because you want to provide supervision to make sure that they're doing it correctly.
but see, that's one factor, but that factor in my mind it doesn't overcome all the other factors that work in favor of an independent contractor. Short-term relationship, it's a specialized skill. They're not using your front-end loader, they're bringing their own, presumably. That looks a lot more, in my mind, like an independent contractor than you owning the front-end loader and contracting with Joe Smith for 40 weeks out of the year to come stabilize stream banks and that, and because that looks more like an employee. When you're engaging businesses, I think you're almost always safe there, quite frankly, as an independent contractor. But a lot of employers don't engage directly with the business; they do it with individuals, and that's the big issue. Go ahead.
Well, I said, what if the person is incorporated as an LLC or something like that, and we're actually contracting with that LLC instead of the individual? Or is that splitting a hair?
No, I mean, it can help, but again, it depends on the overall facts. If that LLC has one client and it's Allegheny County Conservation District for 6 years straight, not good. But if that LLC has 10 or 20 or 80 clients, that's great, you know. And yeah, a one-person LLC, I will say, and I am not a business or a tax lawyer, but I've been told by people who are, one-member LLCs are viewed by the tax authorities basically as non-entities, meaning it's just the person. I can't be Adam Long LLC with a sole member of my, an LLC is a limited liability company. It's a form of corporate structure in Pennsylvania. If I was Adam Long LLC with the sole member of my limited liability company being Adam Long, for tax purposes, the LLC would not exist. It would be Adam Long. That's beyond the scope of this, but yeah, I mean, that's one of the factors you look at, and that helps. That definitely helps the situation.
If you ask them if you're their only client, or how many other clients do they have, can they say they don't have to tell you, or?
Yeah, I mean, I guess what I would say is look at the relationship. If it's a one person and that person's working for you 35 hours a week indefinitely, it's probably safe to assume you're that person's only client. But if they're 2 hours a week, it's probably safe to assume that they need something else to feed their families and have a livelihood. So you can ask them, but I don't think you have to ask them. I think you just.
But they don't have to tell you, right?
Yeah, I mean, it's, you know, but yeah, I wouldn't. There's so many factors that are relevant here, like that. You're not going to win or lose on whether they have 1, 6, or 3 clients. So, but it's just one thing to think about in the overall. The big picture is what matters, basically, and that's what we want to look at: the big picture and all of the relevant factors. For non-exempt employees, what do we need to worry about for them? One, we need to make sure we track and pay for all hours worked. Hours worked can be difficult to define at times. If the person works in an office and punches the clock at 8:30 and leaves at 4 every day and never works before or after that, hours worked are very clear. But there's certain circumstances where employers can have trouble with hours worked, and they're listed there beginning on page 43. A couple points to think about. Hours worked are not the hours we've asked an employee or told an employee to work. And hours worked are the hours worked by the employee if we knew or should have known the employee was working, whether we asked them to work or not. What does that mean? If you have somebody who comes in early, stays late, works through lunch, returns calls in the evenings, things like that, if your thought in your head is, well, I never asked them to do any of that, the law would say that's irrelevant. We knew or should have known they were working, which means we have to pay for that time worked. Well, that may sound very unfair, but the law's response to that would be, that's a discipline problem, not a compensation problem. Meaning, if you've got an employee working outside of work hours and you don't want the employee to do so, make that very clear to the employee. If the employee continues to do so, pay the employee for that time, discipline the employee, and or fire the employee. Basically, because why? Why is the system screwy like that? What's the loophole that's trying to be closed there? You know, I go up to Joe. All right, Joe, you're scheduled to work until 4 today. Now here's a stack of work, which I know will take you 8 hours to get done. I need you to get this done before the end of the day. See you later. And then I turn my back, and Joe knows that Joe needs to work now until 9 o'clock tonight to get all that work done. You know, it's ripe for abuse. We can't just pay on when we tell people to work. So, because otherwise that would be perfectly lawful. You can't work past 4, but here's 11 hours of work to do. So that's why the law says if you knew or should have known employer, and employer is your supervisors, your managers, if somebody there knew or should have known, we need to pay for it. So we need to be cognizant of when an employee is working. Yes?
Question on that. Employee has a smartphone. They check their email at midnight Sunday night to see what all they got to do Monday morning. We officially have to pay them for that time they're on their smartphone checking email.
Is that employee exempt or non-exempt?
Non-exempt.
That's a problem. And that raises a very good point. Mobile devices. Having non-exempt employees who have remote access to your systems, your email, telephone, having mobile devices where their email pops up, that's a problem because that's hours work. That's you're reading your email, you're returning calls, maybe you're sending emails. How's that not work? And what the law would say is, you, the employer, have given them that access. You can't give them that access and say, I'm going to turn around now and I'm not going to watch what you do with it. We knew or should have known they're working. Now the way to address that is to make clear to employees either terminate the access or if that's not operationally feasible, make very clear you're not to access your phone or your email except during these hours or whatever the case may be. Or if you do access it, you need to let us know and we need to count it as hours worked.
Can it be accounted for in your employee policy manual that any non-exempt employee working overtime needs to have that cleared and approved by the district manager prior?
Yeah, you can have that, but then when they work overtime without authorization, you still have to pay them for it. You just discipline them for violating your policy. That's the, again, the whole law is designed to avoid employers creating loopholes to get people to work off the clock. You could absolutely, and I would recommend any policy you have, say, any work outside of your normal work hours must be approved by the district manager, and make very clear. I think we probably have it in the policy you did for Jan, an overtime policy that makes clear that it probably comes right out and says, we will pay for unauthorized overtime, but it'll subject you to disciplinary action. Because it's just too easy for employers to just not pay for it, because then the employer has no incentive to really stop the employee from working off the clock. So that's why what the law says is that's a discipline issue. That's not a compensation issue. But yeah, to the extent that I would go back and seriously think about if you have non-exempt employees with remote access, mobile devices, things like that, how do you want to deal with that? Because you can't just treat them as exempt. You're exempt folks, all you managers out there, your board can say you got to work 80 hours a week and you're not getting a dime extra. And under the law, that's perfectly lawful. Now, you may walk out the door, but on the way the rules are, for exempt employees, you can work all you want. It doesn't matter. You can check that email at 3 in the morning, like many of us probably do. But for your non-exempt folks, it's a completely different situation. And that's why, 5-10 years ago, the only people who had these devices were your exempt folks. As the trend goes to more and more non-exempt folks having devices, mobile devices and that, it's a big issue. Because not only do we know they're working off the clock, we probably have electronic records of them working off the clock with emails and stuff like that. So it's just something to think about. A couple of other areas where sometimes issues arise, preliminary activities and finishing activities. If you got an employee who starts at 8:30 every morning but comes in at 8:10, boots up the computer, checks the email, sends some responses, and basically is engaged for that 20 minutes, those are hours worked for the 20 minutes. You can't just pay off the work schedule if the schedule does not reflect the reality. And there, I almost guarantee you'll have logs of when that computer was booted up and off the person went. So situations like that, you got to be cognizant of it. And every office seems to have one of somebody who comes in early, stays late. We used to have a secretary at my firm who would come in on weekends, unsolicited, and would come in on weekends to catch up on her work. And it was just because that was her nature, that was her personality. She didn't need to come in, but she thought she was the most important person in the universe, so darn it, she had to come in. That's a problem. I mean, you can't just look the other way, unless you're willing to pay for all that time, or give them comp time, as we'll talk about. That's a problem. So, and what the law says is, this is your problem, employer. You need to monitor this. Looking the other way, I had no idea. That's not good enough here, because you generally are going to know what's going on at your districts. And if you have these employees, if you want to avoid risk here, you got to tighten those things up. Waiting and on-call time, I don't know how much of that's done by districts. I'm just going to breeze through that since we still have ways to go. But the rules on use of on-call time, if you do that in your district, you tell an employee, you're on call for the next 6 hours, we'll call you if you need you. The entire on-call period can be compensable hours work if we put restrictions on that on-call, the use of the on-call time, that would limit the employee's ability to use it for his or her own purposes. If we say you're on call for 6 hours, you've got to return any call within 5 minutes and then call that employee 4 times during that time, those 6 hours are all compensable. Conversely, if we say you're on call for the next 6 hours, if we call you, you've got to return that call within an hour, and you can handle any issue remotely via telephone, that's not going to be compensable, because that employee can go to the beach, go to the mountains, and just take a phone call. And you have to pay them for the phone call, but the rest of the time they can use for their own purposes. So the gist with on-call time is, what are the restrictions we place on the employee while on call? Can they still use the time for themselves or not? Travel time on pages 46 and 47. Travel time falls into 3 buckets, essentially. The first is travel all in the course of the day. Meaning, what that means is home to work, work to home, commute time, not compensable, as we all know. Now, once somebody drives from home to work, and then from work drives here, there, all that travel throughout the day is compensable. Basically, you get one free bite at the apple as an employer. Employee can go from home to someplace, and that's free. But once they get to that someplace, if they have to report to that someplace, or if they choose to report there and then start performing work, the clock starts, and any other travel throughout the day is hours worked. Now, what about a special one-day assignment, a la today, for those of you who had to drive some distance to get here? Say you're non-exempt, and say your commute from home to the district office would be 15 minutes. Today, you drove an hour and 15 minutes to get to this seminar. Again, this only matters for non-exempt folks. What the law says is that 1 hour to and 1 hour home would be compensable hours worked. For a special one-day trip, that's not your normal commute. A special one-day trip, all the travel time is compensable, but you can back out what they otherwise would have spent driving to work and back. So if it's 15, in an hour and 15, it's an hour that we have to pay the person to and from, so it'd be 2 hours of compensable hours worked. And then finally, districts are some of the few clients that I deal with that actually send non-exempt folks on multiple day trips, a trip that cuts across more than one day. And in those situations where you have overnight travel involved, all time spent traveling are compensable hours worked, minus the home to work or work to home, with one exception. If an employee travels outside of his or her normal working hours during a multiple day trip, and the employee is riding as a passenger in a car, bus, train, plane, you name it, then the travel time is not compensable. So if you want to send a non-exempt employee to a training in Key West, send them in an airplane on the red-eye flight that doesn't cut across their normal work day. It's not their normal work hours, it's not day. So even Saturday, they normally work 8:30 to 4, and they are riding in a car back from Philadelphia or something all that day. That's still compensable hours work. It would only not be compensable if we made them drive overnight. It is what it is. But those are the rules, and they're laid out for you on pages 46 and 47. Meetings and training programs, things like this. When do we have to pay non-exempt employees for this? Basically, we must pay them, as laid out at the bottom of 47, unless all 4 of those factors are met. The attendance is outside normal working hours, so if any of you are non-exempt and you normally work during the day, congratulations, this is compensable hours worked. So it must be outside normal working hours. The attendance must be voluntary, and that's real voluntary. That's not like, it's voluntary, but I'd really like you to go. It truly has to be, above board, completely at the employee's discretion. The training must not be directly related to the employee's current job assignment. And finally, no work of value to the employer is performed at the lecture, meeting, or training. If all 4 are met, the time is not compensable. If 1 or more of those factors are not met, that's compensable hours worked. Meal breaks on 48. Basically, if you're not going to pay a non-exempt employee for a meal break, it should be 30 minutes or more, and we must ensure that the employee is completely relieved of his or her duties during that time. So what does that mean? I love it when they walk out the door and go down the street to the supermarket or the fast food place, leave the building, come back 30 minutes later. That's the best. What's trouble? When they sit at the desk and answer their phones and respond to email and things like that during the meal break. We know they're working. It has to be an uninterrupted, 30 minutes or more. So, and if you've got employees who are taking calls during a meal break, the law would say that entire break is compensable hours work, even if they only took a 2-minute call or a 5-minute call. So you want to be careful about that. Instruct employees when you're on meal breaks, you're not performing any district work. Simple as that. Or structure that you pay the employee for the meal break. If you pay it, it's not an issue. That's the hours worked issues. The second issue for non-exempt employees is overtime compensation. Overtime is defined as we are obligated to pay 1 1/2 times the employee's regular rate of pay for all hours worked in excess of 40 in any work week. If you pay bi-weekly, it's still the work week. If somebody works 44 hours in week 1 and 36 in week 2, they worked overtime. That wouldn't work. It's not based on a bi-weekly. Every snapshot is the work week. If they go over 40, it's considered overtime. And that's why the hours work thing is so important. Because if you've got somebody who works 37.5 hours or 40 hours a week, but then you get all these little nibbles here or there of compensable hours work, suddenly now you're thrown over 40, now you're into the overtime, which you would want to avoid. So that's the hours piece. But I said it's 1.5 times the regular rate. I did not say hourly rate. If all you pay an employee is a straight hourly rate, it's 1.5 times the hourly rate. But if you pay employees more than simply an hourly rate, those additional payments may affect the employee's regular rate for overtime compensation purposes. And this is where common sense can get you in trouble, and this is a little kooky. I said before, salary versus hourly. If someone's non-exempt, they do not have to be paid on an hourly basis. You can pay folks salaried non-exempt. My example of maybe your receptionist who you pay a salary to, but he or she never works more than 37.5 hours a week. Perfectly fine. The thing that matters about the hourly rate is that's how overtime is calculated. It's paid on an hourly basis. So you pay, say, an employee an hourly rate, and then maybe you want to incentivize your employees to come to work. So you say, if you have perfect attendance for each week, we'll give you a $100 bonus at the end of the week. Great. Under the law, the overtime rate is not just the hourly rate now. You have to factor that bonus back in and come up with what's now the regular rate for overtime compensation purposes. The more you pay, the more your overtime liability is going to be in overtime works, or weeks. Yes.
Item F, that you kind of skipped over.
Sure.
I just want to emphasize that, because that's something I've been doing wrong, that I didn't understand at all. Which
Sure.
was, if someone is taking leave during the week, it does not count as hours worked toward overtime.
Correct.
So if I had somebody on 2 days vacation and they worked 3 days, and then they worked Saturday, I was counting that as overtime hours, but it's not.
Yeah, you can pay it as overtime, but the law doesn't compel that. Overtime is based upon 40 or more hours worked, and that is defined, more than 40 hours worked, and that is truly hours worked. Paid leave does not count. So if you have an employee, and it's any type of paid leave, if you pay 8 hours of holiday pay for Memorial Day, and then you have an employee who works 4 12-hour days right after that, so, well, no, that's not a good example. 4 10-hour days. So they're off Monday, 8 hours of holiday pay, and then they work 40 hours the rest of the week. They're not entitled to overtime, even though they're getting paid for 48 hours, because 8 of those hours are holiday pay that's not worked. So whenever you're looking at the 40 hours, you gotta look at only what was actually worked, not what you paid. The regular rate, we talk on page 49 of payments that can be excluded from the regular rate for overtime compensation purposes. But on 50, we talk about what must be included, and non-discretionary bonuses are one of those things. What's a non-discretionary bonus? Any bonus you tell an employee, I will pay you a bonus if X, Y, or Z happens, or if you do X, Y, or Z. Perfect attendance. Really any bonus needs to be included in the regular rate unless it's clearly discretionary, meaning the employee's not expecting it, it was never promised, it was never implied, it's just at the end of the day or the end of the year, we have some money left over, so we're gonna pay a bonus out. That's okay. But as soon as you start, anything other than that with a bonus, you're going to have to factor it into the regular rate. When things really get crazy is, what about a year-end bonus? You pay perfect attendance bonus at the end of the year for perfect attendance throughout the year. Well, now that bonus was earned in all 52 work weeks, and you actually have to portion it back and pay a deferred and additional overtime. It's called the deferred overtime calculation. It's crazy. There's an example on page 50 and 51 for that. I think basically it's complicated. I'm not going to bore you with it if you have an hour or so to go, but just realize if you're paying your hourly folks, your non-exempt folks more than strictly an hourly rate, there may be overtime implications affiliated with that.
Can I interrupt 1 second, excuse me? There's fresh drinks and cookies in the back, if
Great.
anybody'd like anything.
Thank you. Comp time. As we close up the wage and hour. You're one of the few groups I get to speak to that actually comp time is an option. because comp time is only available in the public sector under the Fair Labor Standards Act. Private sector employers cannot utilize comp time. What comp time is compensatory time off, meaning in lieu of paying overtime compensation, you give the employee time off in the future, paid time off, so that you don't have to pay the overtime. There are a couple requirements associated with comp time that are worth mentioning. One, you have to let folks know ahead of time that you're going to use comp time. You can't just sort of keep it a secret or retroactively apply it. Two, comp time is calculated on time and a half, so that if this week you have an employee who works 44 hours and you wish to give them time off in the future for compensatory time off, you don't give them 4 hours off, you give them 6 hours off, because overtime is time and a half. And this is not designed to limit your overtime exposure, or this is not designed to reduce the value to an employee of working overtime. So basically, as they would get 6 hours of pay for those 4 hours, you've got to give them 6 hours off. Secondly, comp time can only be accrued up to a maximum of 240 hours for public employers like yourself that aren't engaged in certain other public safety and things like that. So 240 is the cap, and that is the comp time hours, meaning 160 hours worked of overtime, that equals 240 comp time hours. Once you get up to 240 comp time hours for an employee, if you want to continue to use comp time, well, you have two options if they continue to work more than 40. One, make them use the comp time. Make them take the time off to lower that balance down. Or two, pay them the overtime. You can't accrue beyond 240, that's not permitted. And finally, any unused comp time must be paid as overtime upon termination. If someone has 80 hours of comp time accrued, they got to receive 80 hours of pay in that final paycheck. They don't lose it, essentially. So comp time is available to you. That certainly should help you from a budgetary perspective. It's a good thing, but just make sure you use it consistent with the legal requirements.
Again, that's just for non-exempt employees?
Correct. Now, that raises a good point. The question was, comp time is just for non-exempt employees? And the answer is legally, yes. But for exempt employees, if they meet the test, one of the tests, and they're paid on a salary basis, you can give them comp time. You can have a comp time program for exempt employees, but it's completely your discretion. It's not, what I would say is if you want to do something like that, put together a policy, put something in writing, and distribute it to the exempt employees.
If you were to do that for an exempt employee, does it still have to be the hour and a half?
No, you have complete discretion with an exempt employee. You can give them half an hour for every hour, not that I would recommend that, but yeah, you can do that. That's one of the quirks. These laws are so narrow and specific, and if you step out of line in one way, you wreck everything. With exempt employees, it's the opposite. If you have an employee who receives a guaranteed minimum salary and meets the test, you can give them comp time, you can pay them overtime, you can do anything you want. You can pay the bonuses, you can say, we're gonna give you a guaranteed weekly salary of $455 a week and then pay you $10 an hour on top of that. You can do that. As long as they meet the test, it's the Wild West when it comes to exempt employees. It's all at your discretion. But non-exempt employees, you got 1,001 rules you gotta deal with. Finally, I know this wage and hour stuff is just, extraordinarily complicated, and there's a ton thrown at you in a short period of time. On pages 54 and 55 of the materials, we put together a bullet point checklist of the most common issues that, if you want to go back to your district at the end of the day and say, I want to think about some of these wage and hour issues, but that hour and a half was just a blur, so refer to this. This sort of organizes for you what do you need, to think about, what questions you should ask yourself. And you'll see the last one on 55 there talks about records. And again, I refer you on page 72. We're not going to have time to go through in great detail a lot of these records, but that is the resource we put together for you on page 72 of what kind of records you should keep as employers, and then secondarily how long you should keep them. So again, that's less of a extraordinarily boring presentation and more of a resource to be accessed at your own convenience. But we'll talk a little bit about that, but that's section 5 there. We refer to that. So moving on to section 4, discipline and discharge. We talked a little bit about at-will employment, what it means and what it does not mean. Now that we've moved into this section, it doesn't mean anything. And the bottom line is the risks are many and varied. When you look at that list of all the different ways that somebody can bring a claim against you, there's so many different ways that someone can challenge an adverse employment action. Unless you feel absolutely comfortable that you have an employee who would never in a million years bring a claim against you, it's almost best to engage in these best practices we're going to talk about, because while sometimes your senses tell you, yeah, this employee is going to give us a hard time at some point, and we know it's coming, and this employee gives us a hard time every step of the way, talks ad nauseum about his or her lawyer, and I always laugh about that whenever employers say, well, I have a lawyer, my lawyer says X, Y, and Z. You know, your lawyer's in your pocket, you don't have a lawyer. I mean, like, but you still have employees who talk about, you know, when you have that employee, that worst case scenario, that employee's actually doing you a favor. Because that employee's making very clear to you that if you're to take action against that employee, you better believe you're gonna get a claim filed or something filed afterwards. So you wanna know that up front so you can make sure you got all your ducks in a row so that if you actually terminate that employee, all right, we're good to go, we got the documentation, we did everything that lawyer told us to do, we're ready. The harder situations, frankly, are when you have an employee who you don't think would ever give you a hard time, you fire that employee, and then you get a letter from a lawyer. Because now you could be in the, oh no situation, maybe I should have done things a little differently if I knew he was gonna bring a claim. But that said, you know, what we talk about in a lot of this portion of the presentation is best practices, guidance and checklists here on things to go through, so that, you know, the best practice is to handle each of these situations in a pretty uniform manner, as if you're gonna get sued. So that you feel, since you don't know when it's coming, you follow these best practices, and they're not, I'd say, overly onerous, but then in that worst case scenario, when that claim's filed, you feel comfortable knowing that we've done what we should do. Because, you know, the claim, there's so many different types of claims that can be filed, anybody can file a claim pretty much. And that's just simply the world we live in. All of these claims, discrimination is at the core of most of, if not all of these claims, discrimination or retaliation. And both types of claims mean, I was treated differently because I am blank. That's a discrimination claim. A retaliation claim is, I was treated differently because I did blank. File the workers' comp claim, requested medical leave, something like that. Retaliation is protected activity, discrimination is a protected trait. And with both is the same analysis, meaning, why did we do what we did? Did we fire the person because of something that's prohibited by law? Or was it because of the non-unlawful reason that we're saying, no, we didn't fire you because of your religion, we fired you because of your attendance. That's what almost all of these claims boil down to. And the law, not surprisingly, has a legal framework to address them. It is extraordinarily rare in this day and age for somebody to, you know, sit down an employee and say, we're letting you go because you're too old. Or here's an email I'm going to send to my board chair saying we're letting Johnny go because he's too old. Direct evidence of discrimination or retaliation almost never exists anymore because most folks are bright enough to not say or do those kind of things and create that kind of evidence. So without direct evidence, how does an employee prove discrimination or retaliation? Well, basically through the use of circumstantial evidence. Almost all of these cases turn on circumstantial evidence. You know, they don't have the footage of the bank robbery, but they have, you know, a whole host of circumstantial evidence to prove that you were the bank robber. And it works sort of the same way. The legal framework is the McDonnell-Douglas burden shifting standard, which is laid out on page 57 and 58. Essentially, this analysis, which was created by the Supreme Court in the 1970s, it's basically a three-step process with respect to any discrimination claim. It starts with whether the plaintiff, the employee, can make a prima facie case of discrimination. I don't know what prima facie means in Latin, but the way that I think of it is, it means foot in the door. This is how you get your foot in the door as making one of these claims as an employee. You must show that you are in a protected class, and we are all in many protected classes, as we've talked about. You must show there was an adverse employment action, and that can include really anything bad that happens in employment. Fired, failure to hire, demoted, failure to promote, wage cut, anything bad that happens. I am blank, I suffered this adverse employment action, I was otherwise qualified, and that's usually not hard to show, especially in a termination situation because they were qualified because we had them in the job to begin with. And then finally, They must show that others outside of the protected class were not adversely affected. You fired me because of my attendance, and there's 3 women in the same job as me who are absent too, and you didn't fire them. Without even looking at the circumstances, that's good enough to make a prima facie case of discrimination. Once that occurs, the burden then shifts to the employer to offer a legitimate non-discriminatory reason for the action. We don't have to prove anything. We just have to say, no, we didn't fire you because of your gender. We fired you because of your performance, your misconduct, your attendance, whatever the case may be. And once we make that proffer, once we proffer that proof, then the burden shifts back to the employee to prove, to basically convince a jury either that the reason that we're offering is false or that discrimination was the real reason for our action. It's called proving pretext. They take our reason and put it on trial. Can I poke enough holes in that reason to show that, no, they didn't fire me because of my attendance. Look at all the different reasons why that doesn't hold water. They really fired me because of something else. And even if they can't provide proof of that something else, if they can poke enough holes and convince a jury that our reason is pretext, meaning false and to cover up for something else, they win. And that's really what all of these cases come down to. Virtually every plaintiff can make a prima facie case, and every employer better be able to offer a legitimate non-discriminatory reason. If we get sued and we have to stand up and say, we have no idea why we fired this person, Your Honor, we're not going to win that case. So we're always going to be able to give a reason. And they're always going to be able to make a prima facie case. So everything comes down to this third point, the pretext issue. And there's a great block quote. I don't put a lot of court decision quotes in here, but on page 58, there's a great block quote from the Third Circuit Court of Appeals, which is the federal appellate court that covers us here in Pennsylvania, that really just lays it out. I won't read it all to you, but basically lays out exactly what the pretext analysis is, and also in a way that's very positive for employers. I quote that a lot because I like the way it's written. So how can a plaintiff prove pretext? How can they poke holes in our reason? Well, there's lots of different ways, and they're laid out starting on page 58. More favorable treatment of similarly situated employees outside the protected class. You fire an employee because of attendance, and that person can show other people had worse attendance and was not fired. Or in the past, we didn't fire employees for similar circumstances. Basically, when you're making that argument, the employee's not denying the underlying reason for the termination. They're not saying I wasn't absent, or they weren't saying I was a great performer. They're saying, yeah, but you treated me more harshly than you treated somebody else. That's discrimination at its core, and that comes up a lot. I mean, when you're looking at these situations, when I get these calls, and I work through these things almost every day with employers, here's the situation, what do you think? Should we fire? I'm almost always going to go to, well, has this situation ever come up before? What did we do? Consistency is the key in employment decisions. General rule of thumb, you should always be consistent, and if you're not going to be consistent, have a very good, clear reason why you're not. So I'll take that back, you shouldn't always be consistent because you can't. I mean, I remember, years ago, a great quote about the former coach of the Dallas Cowboys, Jimmy Johnson. He talked about, he had 3 stars on his team at that point, Troy Aikman, Emmitt Smith, and Michael Irvin. And someone asked him, do you treat them the same as you treat your other players? And he said, of course not. They're my stars. And that's a little different context, but you don't always have to treat all employees the same. If you have a 30-year employee who does something, that doesn't mean you have to treat that person the same as somebody who's been there for 2 weeks. You can treat employees differently, but if you're going to, make clear that you make sure that you got a good reason to do so. Well, yeah, we're obviously somebody in their probationary period, we're going to maybe be harder on than we would be on someone who's a long-term employee, or that's a different kind of job. That job's harder for us to fill, quite frankly. So it's always best to be consistent, but you don't always have to be consistent. And if you're not going to be, make sure you have a good reason, because if you don't, you're right in category A there of more favorable treatment of similarly situated employees outside the protected class under similar circumstances. On page 59, next reason, conflicting reasons for the adverse employment action. What does this mean? Sugarcoating. You gotta let an employee go. That is often not a fun thing to do. It's almost always not a fun thing to do. You basically have to sit that person down and end their employment. you've known this person for a long time, you don't like conflict, you don't wanna, you don't wanna hurt their feelings and kick them when they're down, so instead of telling them they're a lousy performer, you're just gonna say you're eliminating the position. The grant went away, we don't have the money anymore, sorry, gotta let you go. Great. And then that employee goes and picks up the paper 2 days later and sees his job posted there to be filled at the district. That wasn't what happened. We do need that job. The grant money didn't go away. We just tried to sugarcoat it to avoid making a difficult situation more unpleasant. Well, the reality is now you have a former employee who knows you lied to him. And that is never a good place to be. Because while all of these cases, all these things I haven't used the word fair today at all. Fairness. Because these cases, nothing about this is about fairness. It's not unlawful to be unfair. But when an employee believes you're being unfair, you're much more likely to get a claim filed against you. And it won't say unfair, they'll go to a lawyer and find a way to shoehorn it into something that's protected. But it takes two things to make an employment claim. One, something bad happening to someone, which many times we can't avoid. And two, someone who's angry. It's as simple as that. Happy people don't file lawsuits, angry people do. And we can't necessarily avoid making people angry at times, but there's ways that we can and limit the number of people that we make angry, and one of the easiest ways to make somebody angry is to lie to them. Because we may feel like we're doing them a favor, but the moment they find out we lied to them, they're going to think we're hiding something, we've done something wrong. So you're likely to get a claim, you've got someone who's upset, and then on top of all of that, remember what this is all about. Proving that we're honest, we're not being honest with our reason. So when you sugarcoat and lie up front about it, and then they sue, you put your lawyer in the position of saying, Judge, Your Honor, I know we lied the first time, but trust us, we're telling the truth this time. And that's not the position you want to be in. And it sounds silly, but it's very easy to sugarcoat. It's an easy way out in a lot of ways. The law does not compel you to give a reason for terminating someone's employment. I would say the vast majority of circumstances you should, because that's the right thing as a human being to do. To say we're letting you go, but I'm not telling you why, is a really bizarre conversation to have, and typically doesn't have that employee leave feeling too comfortable and trustworthy, full of trust at that point. So you don't have to give a reason, you usually should and will, and if you will, 2 rules of thumb. Be honest and be general. Honest is self-explanatory. General is, if you're firing somebody because she was late for work that day, don't tell them, I'm letting you go because you were late for work today. Tell them I'm letting you go because of your unsatisfactory attendance, which today was the umpteenth time you've been late. When you say just that, the straw that broke the camel's back, all that employee hears is that last thing. And they're going to say, late today? Well, Susie was late yesterday, you didn't fire her, and I'm mad, and that's unfair, and where's the lawyer? And when you give a reason, be general about it. Honest and general. Say, if it's performance, say performance. Don't say because you screwed up that report yesterday. Say your performance has not been satisfactory. As an example, yesterday the report you screwed up. Give examples is fine. And you can give particulars, but always make sure you give the general reason, because otherwise what will happen is if we just say one thing and later we try to fill in the blanks with the general reason, the employee's going to say, well, you didn't tell me that when you let me go. Termination meetings, you're nervous, they're not fun. That employee's hearing every word you say and a whole bunch of words you never said. They're going to remember everything that happened during that meeting. And that's why it's important when you're in that meeting to make sure you handle it in the right way. So be honest and be general. You can give examples, but don't just focus on the straw that broke the camel's back. Inconsistent policies or evidence. What's that mean? Terminating an employee for poor performance. You look back at the performance evaluation that was done 3 months earlier and it listed the employee as satisfactory. Now maybe things did change in 3 months, but if your story is that this employee's always been a lousy performer, why do we have a satisfactory performance evaluation? That's how they poke holes in our reason. We're on trial. Our process is on trial. Our professionalism's on trial, and how we handle these things is on trial. It's all about poking holes. It's all about casting doubt. It's not about proving really anything. It's about just throwing everything you can up against the wall and hoping something sticks. And that's why when these cases come up and when I'm going through this analysis with an employer, should we let this person go or not? I'm poking the holes. I'm approaching it like I'd be a third party. Well, what about other people? What's the performance evaluation say? What have we told this employee in the past? If it's a performance issue, have we talked to the employee? Have we documented that? all these different things that matter, so that if we're ever called, if we're put on trial, we feel comfortable, we can show, look how professional we've been about this. We handled it the right way. On page 60 and 61 through 63, we put together here a checklist for you. This is something that I hope, if you're in that unfortunate circumstance where perhaps you're disciplining employees or even at the point of discharge for poor performance, we have lists of questions here to consider. These are the questions to ask yourself. What are the answers to these questions? And as you walk through that, if you feel comfortable with, those answers sound pretty good, then you can feel comfortable moving on. But if you're going through there and realizing, well, no, not sure about that one, then you realize you might have more legwork to do in a difficult situation. Discharging for poor performance, on page 61, the most likely claim to be filed, the most likely circumstance where an employee is going to file a claim is where the employee was caught flat-footed, never saw it coming. Meaning, are you always going to have an employee agree if you terminate that employee that, yeah, you're right, I'm a pretty lousy employee, have a nice life? Probably not. But there's a big difference between firing somebody who may not agree, but maybe saw it coming, versus somebody who gets up every morning and says, you know what, I may not be the best at my job, but I'm better than those other 3 people. And you know what, my boss has never talked to me about anything bad. I do okay at my job, and I provide for my family. All's good. You go to work one day, and the boss calls you in and says, you're done. Your performance is unsatisfactory. The employee is just blown away. Never saw it coming. And that employee's going to get angry. That employee's going to say, wait a second, you didn't even give me a warning, nothing, you just called me in and fired me? I had no idea anything was coming. What? I got to go home and tell my loved ones and kids and that? Yeah, I went to work and got fired today. I mean, that's a horrible position to be in for anybody. Now, sometimes you have to do that. Now, that's the situation where the person comes in and never sees it coming. Now, how about a situation where you have an employee, maybe it's either a new employee or a long-term employee who's starting to slip, some performance issues. So maybe you as the manager just pull the person aside and say, hey, I've noticed this recently, here's a couple things you should look for, you got to work on, you got to be better about this, you got to be better about that. You don't give, and no write-up, nothing in writing, you just have that conversation and you give it some time. Performance isn't improving. Then maybe you sit that employee down and maybe give them something formal in writing and say, look, these are the areas we need to see improvement, whether you call it a written warning or a performance improvement plan or something. The employee may disagree. The employee may not necessarily, think this is the right thing or agree with every point, but we lay it out, we make very clear our expectations. This is as clear as we can be. This is what we expect of you in your job. Give it to the person, give them a reasonable time to show improvement. They don't improve. Then you call that employee in and terminate the relationship. Now that employee may not be happy, may disagree completely, but that wasn't a shock. That employee had to have seen it coming by that, because we did our homework. We laid the foundation. We communicated to the employee our expectations, and the employee failed to meet our expectations. When an employee files one of these claims, whether it be a discrimination claim with a state or federal agency or in court, that's what they're looking for. These investigators, well, where's the write-up? Where'd you let him know he or she wasn't, meeting your expectations? And if we can show, here's when we talk to the person, here's the write-up, here's the foundation, we're going to win that case almost every time. Right out of the gate. We show that investigator right out of the gate, we're professional, we take this seriously, we know what we're doing. Conversely, yeah, we fired this 5-year employee for poor performance. So were any warnings, write-ups? Nope. Let me see the performance evaluations. Satisfactory, satisfactory, satisfactory. Well, actually, the employee's claiming that you fired him because he filed a workers' comp claim 3 months ago. Now we're in trouble, because now we don't have that foundation. And that's why discharges for poor performance should never come as a shock to an employee. Because if we've done our homework and done what we need to do, they may not agree, but they shouldn't be shocked. Now, there are times where misconduct, there you may fire for a first offense. That's a whole different animal. Where you got somebody who's engaged in a policy violation, there you definitely have more leeway, because our expectations are made clear in our policy manual or handbook. We don't tolerate X, Y, or Z, and we caught you engaged in forgery or sleeping on the job or something. There it's probably less important to lay that foundation. It's still helpful if it's not the kind of policy violation that would trigger termination for the first offense. But, definitely with poor performance, we have to make our expectations clear and give the person an opportunity to improve. But what about like misconduct situations? And we talk here about disciplinary infractions and investigation. One of the things that's important when we're investigating employee misconduct, we're almost sort of like law enforcement to some degree. We have to do an investigation, and we have to be fair in our investigation. We don't want to leave, gaping holes in our investigation where, well, I told you I was with employee A the whole time when the petty cash got stolen. How can you didn't even talk to employee A, you just fired me. That's the kind of thing we want to avoid. Again, a professional approach to this is when we do an investigation, do we have to, go crazy and shut the place down and turn it into law and order? And no, but we want to go through and make sure we reach a point where we have a good faith belief that if we're going to say somebody violated our policy, especially if it results in termination, we want to feel like we've done enough of an investigation to feel at the end of the day that, yeah, we have a good faith belief. How about proof beyond a reasonable doubt? Not necessary. We're not sending anyone to jail. We can fire people and be wrong. That's one of the questions I often get. Sexual harassment. We investigate a sexual harassment complaint and we fire the male employee for harassing the female employee. He denied it every step of the way. It was he said, she said. We found her more credible, so we fired him. 6 months later, we find out that he told the truth. Can he sue us? No. No, we can be wrong. There's nothing unlawful about being wrong as long as we did a good investigation. Courts get it wrong sometimes. There's nothing wrong with being wrong. It's the process that matters. Doing a professional investigation and making sure as we go through this, we feel comfortable with the conclusions that we reach. On page 62, we have some things to consider, best practices for conducting termination meetings. Generally, we recommend having 2 people in a meeting like that. Again, as difficult as it may be for you, that employee will remember every single thing that happened in that meeting. Not always accurately, but there will be very vivid memories for the employee. And it's good to have 2 people there to avoid a he said type situation. So that you have 2 people. Could be a second person just there taking notes, but just somebody who's there as a second witness. Another thing to emphasize, and I don't mean to, this is something that you may say that, why would you even need to say that, but you'd be surprised how often I see this even by good people in situations like this. Always do these actions in as humane a manner as possible. And what do I mean by that? Well, we got to let this person go, but we've got to protect our internet and all, or we got to protect our email and that sort of thing. So I'm going to call the person in, and then we'll have security march them out the door, and then we'll box up their stuff and mail it back later. There may be times where that's absolutely the appropriate way to go, but sometimes I think employers get so locked into preparing for the worst that they make a bad situation worse because these are very emotional situations for employees, and doing it in a way with dignity can earn you a lot because they're upset enough that they're losing their job, but to treat them in a way that is very undignified it has cost to it. What am I talking about? Can you do it at the end of the day so that it's not, the person doesn't have to march out in front of everyone? That's also can be helpful because sometimes those people can get pretty vocal and create a scene, and it'd be better if no one else is there when they're creating the scene. But, think about logistics when you're thinking about a termination meeting. Protecting our assets is a very important consideration, but it's not the only consideration. And sometimes I see employers go too far the other direction with having lots of great security precautions, but frankly, they're overkill. And sometimes they make the situation worse. So there's a balance to be struck when it comes to protecting your assets, protecting your employees, but also if there's a way that we can keep the temperature down on this, it's better, because the less we anger the employee, the less likely they're going to come back and make a claim, quite frankly. If we can do it in a way, again, we've got to strike the balance. We've got to protect our stuff. We can't allow, we don't want to fire somebody in a traumatic situation, let them go back in their office and shut the door and start firing away on email and stuff like that. We've got to logistically think about shutting down email and those sorts of things. Access to the office. What I've done in the past is a termination meeting, and especially if people are still at work or if it's rather emotional. Look, why don't give us a call, we'll set up a mutual time, you can come back and pick up your, pack up your stuff, or we'll pack it up and send it to you, or let the person in the office at that time supervise, whatever's appropriate, but you've got options. And think about these things logistically going through, because if all you're focused on is the talking points of what we're gonna say in the meeting, and you don't think about these other logistical items, sometimes things quickly spiral out of control, especially if you don't do a lot of these terminations. So we talked there about the under point 5 of taking care of the logistics. Managing absences under the FMLA and ADA. My understanding is there's only one district represented here that has county employees. So, so I'll at least get to explain one of my favorite nonsensical quirks in the law. The Family and Medical Leave Act, the FMLA, is the law that provides employees with up to 12 weeks of non-paid leave per year for qualifying circumstances. The employee's own serious health condition, to care for an immediate family member with a serious health condition, or the birth or placement for adoption of a child. The FMLA applies to employers that have 50 or more employees within a 75-mile radius. It's not designed to apply to smaller employers. However, the FMLA applies to all public sector employers. So you may be thinking, oh, it applies to us. And it does. You are covered by the FMLA. However, to be eligible for the FMLA, an employee needs to work at a job site where the employer has 50 or more employees within a 75-mile radius. So smaller public sector employers like yourselves, other than our district that has county employees, if your employees are your own employees and not the county's, odds are you are covered by the FMLA and you have no employees who will ever be covered by the FMLA because you're not big enough. You don't have 50 employees. And actually, technically, under the law, you'd be required to have an FMLA policy, put up the posters, and do all of that, all of which are required, and advertise this wonderful benefit provided by federal law to all of your employees, and then, oh, by the way, none of you will ever be eligible for it. That's the law. What I would tell you is, I would not have an FMLA policy and poster if you do not qualify. And if you're independent, unless you've got 50 or more employees, you're not likely covered. Now, if you have county employees, yeah, the county's big enough, you're going to have to be covered. But for those of you, the FMLA generally would not apply to you, your employees specifically, because of that fact. But the ADA, and specifically the Pennsylvania Human Relations Act, would apply to you. And in a nutshell, in 2009, the definition of disability under the ADA was greatly broadened by legislation that was passed. Basically, the definition itself did not change, and that definition is on page 67. Basically, a disability is a physical or mental impairment that substantially limits one or more major life activities. A record of such an impairment or being regarded as such, of having such an impairment. When the ADA was first passed, courts interpreted disability very narrowly. It was hard to show one had a disability. With the ADA Amendments Act in 2009, that completely turned on its head. Now that definition is interpreted very broadly. And one of the ways it's interpreted very broadly is the Supreme Court had previously said that when you're considering whether someone has a disability, you consider any mitigating measures that they take. What about if they take their medication, if they use this equipment, are they still substantially limited in any major life activities? Now, when you consider whether someone has a disability, you do not consider any mitigating measures, which means if you have an employee who's diabetic, you ask yourself, would they be substantially limited in any major life activities if they do not monitor or treat their insulin? Most diabetics, the answer would be absolutely. High blood pressure. Take maintenance medication, you're fine. The analysis is, if the person stops taking his or her high blood pressure medication, would they be substantially limited in any major life activities? Heck yeah. I mean, that's a very serious situation. So now, the bottom line is, it's not hard at all to establish a disability under the ADA. And we talk about what major life activities are there on page 67. They've also added major bodily functions to this test, and those are also listed there. It's a non-exhaustive list. The bottom line is, when you have an employee with a non-temporary medical issue, like a broken leg, no. But something that's long-term or permanent, and it's a pretty significant medical issue, they likely qualify as having a disability under the ADA, which means they're entitled to accommodation. Where that gets really tricky is in the leave situation that we talked about. Essentially, we know what the FMLA says, 12 weeks every 12 months. It's pretty straightforward. The ADA says we have to offer reasonable accommodations. What does reasonable mean? No one knows. So, essentially, does that mean if someone wants 3 months off of work, do we have to give them 3 months off if we're not FMLA covered, if it's, say, to get cancer treatment or because of back surgery? What the law would say is you must look at that situation on a case-by-case basis. Is it possible for us to grant that accommodation, that time off, or would it be an undue hardship on us? And there are lots of mushy questions without clear answers, quite frankly. And I would say as smaller employers, as districts typically are, you probably have a stronger basis to say, no, we can't grant an extended leave because we just don't have the workforce, we don't have the number of employees. There's a reason the FMLA only applies to larger employers, because if you've got 100 employees, you can fill the gap when one person's out a lot easier than if you have 8 employees and one person leaves. But unfortunately, the answers aren't always black and white in these situations. So, generally speaking, if I'm in your shoes and I have an employee come to me and say, I need time off, I need X number of days or weeks off, and it's more than maybe the paid leave allotment that the employee has, you can't automatically say no. I would not automatically say yes. What I would do is ask the employee to provide information from his or her treating healthcare provider, substantiating the need for the absence, how long is the duration, of what's the expected return to work date, and what medical restrictions we anticipate the employee having at that time. You may be thinking, whoa, we're asking for medical information. I thought we never want to ask for that. We are certainly able to ask for medical information as part of this process. When an employee is asking for an accommodation, we don't simply have to take the employee's word for it. And I would advise that we do ask for it, especially in those situations. We need an expected return to work date and any restrictions anticipated at that time. Why do we want to know that? Well, certainly for planning purposes, because if the person says I can come back in a week, that might be a whole different answer than if I can come back in 6 months. So that's important. Frankly, in situations with extended leaves of absence, I ask that question because I'm looking for one answer, unknown. Expected return to work date, unknown. Courts have been pretty clear that a leave of absence of an infinite duration is not a reasonable accommodation. So if we're looking for, if we're looking to end the relationship in a situation where an employee's been off work for a prolonged period of time, we want to ask that question, and cynically, what we would like to hear is no. I have no idea when the person can come back to work. That gives us greater flexibility than if what we hear is a month. Because if it's a month, then we have to decide, is an additional month of leave a reasonable accommodation? And there really is not a lot of clarity on the answers to that. It's a complicated, there's no clear answer either way. But, just keep that in mind. Even if you're not you don't have FMLA eligible employees, the ADA is still out there, or the PHRA for those of you with less than 15 employees. And it is certainly something that potentially has very expansive rights for employees. Just because an employee is missing, and this applies also, frankly, what if it's not asking for 3 weeks off or 3 months off? What if it's just calling off once a week? Well, if we have to ask why the employee's calling off. And if the answers that we get in return are, dog was sick, car broke down, had to stay home for the guy to fix the water heater, none of those are protected. So then we can feel pretty confident saying, that's unsatisfactory attendance. But what if everyone is migraine, 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 migraine? Having migraine can be a disability. And if all those absences are for one reason, we've got to dig deeper and engage in that interactive process, have the employee get us medical information so that we know going forward, how much does the doctor anticipate the employee will need to miss work? That's what we're looking for going forward. Because if the doctor says, oh, he may need to miss 3 days a week forever, then maybe we say, that's not reasonable. We can't accommodate that with 8 employees. We can't have somebody who just never comes to work. But we still need to go through those steps. I've long said that the ADA interactive process, whenever you're dealing with employee medical leave or employee medical related absences, it's like a chess match. You can't jump right to checkmate. And even if you ultimately end up at a place where you can terminate the employment, with relatively low risk, it takes multiple steps in the process to get there. And that's very frustrating for a lot of employers because after all, we hire employees to be at work and get things done. But unfortunately, that's the legal framework in which we operate. We can't jump to checkmate. We need to ask for the information. We need to assess the information. We might need to give some time off at first, see how it goes. Does it get better? Does it get worse? But eventually, because the position we want to be in, since the test is a reasonable accommodation, that's the obligation, and I honestly can't define for you really what that necessarily means in all circumstances, the best position to be in to defend a failure to accommodate claim under the ADA is to say, look, Judge, we did this, we did that, we did that. What more could we do? Because that's really our response. I mean, it's undue hardship is the test, but really it comes down to what more could we do? Look, we gave him 3 weeks off, or we gave him 3 months off, and then he came back and he's missing all this time. We went back and forth, continue to miss time. This has been going on for 6 months. We have a district to run. What more could we do? The stronger we can make that argument, the better chance we have of winning, of defending a claim like that. If instead our response is, well, the employee called off 3 times in 3 weeks for migraine headaches, so we fired the employee. I can't say what more could we do, because there's a lot more that we could have done. Ask for information, assess the information, all that sorts of thing. With respect to the scenarios on page 69, ADA or disability-related leave often becomes a big issue for those employers covered by the FMLA when the employee is unable to return to work after the employee has exhausted all 12 weeks, believe it or not. Someone's out for 12 weeks, your FMLA's up, I need another 3 weeks off. Bottom line is that may be a form of a reasonable accommodation, so we have to be cognizant of that. We can't have a policy if we do have FMLA eligible individuals of saying 12 weeks and you're out. We basically have to, once the 12 weeks are exhausted, get information, assess the situation, and make a determination. And on page 70 and 71, that scenario, which you can review in the privacy of your own chambers, is another one. That's the one where the employee just keeps missing time. And what I often say in these situations, the more time the employee misses, the stronger our position is to terminate the relationship. So a lot of times employers want to short circuit this process, and a lot of times, unfortunately, I'm in the position of, look, let's get more information, let's find out where they are, let's find out what the doctor anticipates, realizing that the more and more they're absent, the stronger that our position then is to say, look, this isn't a reasonable accommodation. Coming to work is an essential function of this job, and this person hasn't come to work more than a couple days in 6 months. That's the position you want to be in.
What benefits are we required to maintain while they're on unpaid leave?
Good question. The question was, what benefits are we required to maintain while an employee is on an unpaid leave of absence? And an ADA leave, like we're talking about here, can be unpaid. There's no obligation we pay. We may have policies that provide for paid leave, but if the person has no paid leave available, the time off can be unpaid. What about health insurance? Benefits like that. What the law essentially says is we have to treat someone in that situation the same as we would someone taking a leave of absence for a non-medically related reason. Now, of course, the reaction many of you might have is we wouldn't give someone 3 months off for a non-medically related reason, time off. And I recognize that. So the bottom line is you generally have a fair amount of flexibility in terms of what I would have. You don't necessarily need a policy in writing, but a general policy, something informal where if an employee goes out on medical leave, we'll continue the benefits for 30 days, whatever you're comfortable with, and then we're going to terminate the benefits so that we treat everyone relatively the same. I work with employers that are FMLA covered that will continue the benefits for 12 weeks because the FMLA does require continued benefits, and then terminate the benefits. You really can decide, but you want to try to be consistent. I would say, I hate the phrase setting a precedent because that has much more application in the union context, but then here, like I said, you want to be consistent, but you don't always have to be consistent. But this is one area where I would advise being as consistent as possible, where, if somebody needs to be off work for 3 months, do we want to pay for 3 months of benefits? If not, do we want to tell them we'll pay for 30 days and then we're going to COBRA you, and you have to pay for your own benefits at that point? You can make that a call, just try to be consistent across the board. And one thing, that raises another point that's definitely worth talking about. A frequent call that I get is, we have an employee who's been off work for 6 months, I don't have any medical update, they haven't paid their share of the health insurance premiums, and I want to terminate the benefits and fire them. Problem there is, while you might possibly be able to do so, that's checkmate, and we're still at the first move of the game. You must monitor employee leave situations. Even if you don't have carte blanche to fire an employee or put hard, you gotta come back by X date or you're done, you always wanna have up-to-date medical information and you wanna have a game plan going in. Because one thing you can't do is pay for the benefits for 6 months and then say, well, now I'm gonna go back and make them pay me all that their share of the benefit, whatever the employee's share of the premiums are. You can say up front, you need to pay us your share of the premiums and get us the check by X date, or we'll take it out of the paid leave, that's fine. But where employers get in trouble is taking a messy employee leave situation, just pushing it off to the side, out of sight, out of mind, and then 6 months later getting really frustrated and calling me and saying, I want to fire that employee now. We've got to work the process. We've got to communicate through the process. We can't jump right to checkmate. At the 6-month mark, or maybe even earlier, you might definitely be able to fire an employee in those circumstances. But you can't go from silence, no communication, to termination in 6 months. Because you may say, well, the employee didn't communicate with us, but the law would say, that's your job, employer, to reach out to that employee. The onus is on us as an employer. Agree with it or not, but that we don't want to be in that position. So certainly if you have those situations where employees are out on extended leave, know where they are. What's the current medical information? What's the current expected return to work date? When that gets closer, follow up with the employee. We have you down as returning to work on May 8th. Will you be back then? Well, no, I think I'm going to be later. Then I need a new note from your doctor with an expected return to work date, that sort of thing. You want to stay on top of these things. And health insurance is a perfect example. If you don't want to continue the medical insurance for a long period of time, make that decision early on, communicate it to the employee. You can't do it later and try to unring the bell and go back and take it away. We have to be proactive and on top of these things to manage them properly. Record keepings and postings, in the last 15 minutes or so that we have, just very briefly through these last 3 sections. Personnel files. Employees have a right to review their personnel files. They can request the right to review. We can require that it occur at a reasonable period of time. I would highly advise that we have a manager or supervisor present during the review. You don't want to give a disgruntled employee his or her personnel file and close the door and leave the room, unless you're more trusting than I ever would be. You can have somebody review, the employee can make notes, the employee can provide a written statement to rebut something that's in the personnel file. The employee is not entitled to a copy of anything that's in the personnel file. You can provide copies if you like, but there's no legal requirement that we do so. The employee is not allowed to write on something in the personnel file, or it's just simply to review, take notes, and that's pretty much it. Now, these rights also, although they apply in the law only to employees, courts have recognized and held that recently terminated employees have these rights. So you can have a fired employee or a recently separated employee say, I want to review my personnel file. We shall allow that to occur. That said, one option is to say, we'll make you a copy and send it to you. If you don't want that employee back in your offices, you can always just send them a copy and that's good enough. You don't have to make copies, but that is your discretion. And it's something to definitely consider with former employees. And sometimes, even worse, that request comes from a lawyer. I represent employee Joe, you recently fired him, I want to review his personnel file. Or I want a usually attorneys want copies because they don't want to be bothered with coming to your offices. In those situations, I would make the copy because the employee is allowed to authorize a representative to review the personnel file, and that could be a lawyer. You don't want a lawyer in your office digging through a file, so make a photocopy and send it off. But just recognize that that's a protected right that employees have.
You have to show them everything that's in that personnel file?
Well, yeah, you have to show them everything that's in the personnel file, but not everything has to go in the personnel file. And what do I mean by that? We list on page 72 and 73 what generally should be included in a personnel file. Now, there are certain things that don't need to be included in the personnel file. One of which, and we talk about a little later in this section, something that we refer to as a manager's desk file or manager's notes. I highly recommend that each of you keep such a notebook or something, almost in a Dear Diary format of if something happens during the course of the day that is noteworthy, good or bad. If you do performance evaluations for your employees, you maybe do them once a year. Say you do them in December, maybe something happened today that you want to remember in December, so you jot something down in your notebook. It's not something that triggers disciplinary action, it's not a written warning. Maybe you just talk to an employee about a off-color comment the employee made. It doesn't rise to the level of a written warning, but just you pulled the employee aside and said, we can't have that. Jot it down in your notebook. Talk to an employee about performance. Doesn't have to be every time you talk to employees, but if your spidey senses tell you that I could see this ending badly, and this is step one of the verbal discussion, maybe you want to make a note to yourself. I talked to Joe today about about the following areas where his performance has been deficient. That kind of stuff doesn't need to go in a personnel file. Those can be your notes as a manager. They are incredibly valuable in the event that a dispute ever arises, because the way these investigators approach these cases, if it's not documented, it didn't happen. Because we can say, yeah, back in 2011, I talked to Steve about the following issues. Do you have any notes of that? No, I just remember. Who can remember 3 years ago? I can't remember literally 2 weeks ago. The bottom line is, documentation is so key in these situations, and one of the easiest ways to document things, people hear that and they think, oh, then I gotta write some fancy, memo to the file, and I gotta worry about, did I spell words wrong? No, it could be on a napkin, but something in writing that just reflects that on this date this happened. And a napkin may be a little extreme, but just a notebook or something that you keep that you could remind yourself when something has occurred. So that maybe when you go back and do that performance evaluation, if you want to talk about that event, you have the little notes. And it doesn't have to be perfect English, it doesn't have to be complete sentences, just something. Scribble something down so you have it, and you have that record. So to your question, yeah, they have the right to review the personnel file, but there may be circumstances where things don't go in the personnel file. Every employer should keep a separate file for each employee, a personnel file and an employee medical file. Because of the confidentiality protections that are in place for employee medical information, it's good to have, many employers, even to this day, just throw everything in the personnel file. Doctor's notes from the employee, notes regarding benefits paperwork. The best practice is to have 2 separate files. Keep that confidential medical file under lock and key. Then there's never any argument. Anybody monkeyed with somebody's medical info or found out that Johnny has whatever. It's just better to do it that way. And we list on 74 and 75 the types of documents and information that should be in that separate medical file. Skipping ahead to the I-9 file, this is less of a big deal for smaller employers like yourselves, but the best practice is most employers put the I-9 form. The I-9 form is the form completed by individuals that confirms their right to legally work in the United States. It's basically the immigration form. And that form, the best practice is not to put it in the personnel file, but to keep all employee I-9 forms together in their own separate file. If you have a lot, organized by year, but if you just have a handful of employees, keep them in a separate file. The reason why is if you ever get a knock on your door whereby a government agency wants to audit your I-9 files to make sure that everyone's legally authorized to work, it's very easy to just produce that file rather than digging through stacks of personnel files. Manager desk files, they're on 79, that's what we talked about. What should be in there, what's good to document. I've seen this done lots of ways. I've seen folks, like supervisors, put it on their calendars, like folks who still use a paper calendar, to write stuff in there. Electronic can be fine if you just want to type a file, obviously make sure it's secure. I had the question asked of how long, what should you do with a manager's desk file when you're no longer the manager? Like if you retire or something like that, because this is your file. This is not, it's the district's file, but it's specific to you. In those situations, what I would say is you really have a choice. If you're retiring or leaving and you wish to leave that file for your successor, that's fine. If you don't feel comfortable, I would keep it for some period of time, maybe a year or two after you leave, just in case something comes up. And then if you had good notes on the situation, you still want to keep that, because even though you may have retired, you can get drugged back into these things. two things that are important to know. One, the statute of limitations to file claims, employees under some of these laws have up to 2 years to file a lawsuit on the basis of, like, say, an FMLA claim or FLSA, misclassification. They have 300 days to file a charge of discrimination with the EEOC. Often, when charges are filed with government agencies, you don't find out about it the next day. Months can pass before you get served with that charge. So, a lot of times, an event happens today, and you only find out that it becomes a legal issue a year from now or more. And that's why you have to keep things for longer periods of time than you might otherwise think sometimes. Starting on page 80, we lay out our record retention guidelines, which is suggestions on how long to keep these files. Because again, with the whole limitations period, folks can file lawsuits a lot later than what you might think. So those are all laid out for you there. Page 83 and 84, we list some of the employment law postings that are required of many of you as conservation districts. One of the things that we added for this version of this booklet is the revision date. So if you want to go back to your bulletin board where you have your employment law notices posted, even if you have these notices up, make sure you have the current version. And if you don't, there are two good places to find many, most if not all of these forms. For the federal forms, you can go to the U.S. Department of Labor's website. They have a handy page, if you navigate through there, that will have a link to most of the federal forms listed here. And similarly, the Pennsylvania Department of Labor and Industries website, they also have the state forms there for you. So they're two sort of one-stop shopping type places for federal and state forms. Sunshine Act, very briefly, this is in here again more as a resource for you because it's not really employment related, but it's something that comes up, the districts come across many times. Basically the Sunshine Act is the right of the public to be present at all meetings of agencies and to witness the deliberation, policy formation, and decision making of the agencies. The act covers conservation districts. You are covered by the Sunshine Act. Basically, the requirements focus on open meetings, official action and deliberation by quorum of the members of the agency must take place at an open meeting unless the meeting may be closed under one of the exceptions or as an executive session. Any official action, since official action must take place at open meetings, the definition of official action is there at the bottom of 85 and top of 86. Meeting is the definition of meetings listed there on page 86. As part of the open meeting requirement, the votes of each member who actually votes on any resolution, rule, order, regulation, or the setting of official policy, the vote must be publicly cast. Written minutes must be recorded, and there's information on what must be included in the minutes there for you. The two main exceptions to the Sunshine Act's open meeting requirements are for conferences and executive sessions. We define what conferences are there at the bottom of 86. Executive sessions are there on 87. Permissible purposes to have executive sessions include to discuss personnel matters. Since none of you have union represented employees, the second bullet won't apply to you. But to consider the purchase or lease of real estate, to consult with an attorney regarding litigation, and to discuss agency business that would lead to disclosure of confidential information. But keep in mind, even if you have a permissible purpose to have that executive session, any official action that takes place as a result of the discussions at the executive session must occur at an open meeting. There's a requirement for public notice of open meetings. That's defined for you there on 87. We must give reasonable opportunity at each advertised meeting for residents or taxpayers to comment on matters of concern, official action, or deliberation that are or may be before the board before taking official action. So you got to make sure you structure the meetings in a way that can occur. Then we put together a number of questions and answers there on 88 and 89 for you, bleeding over onto page 90. We added one to this year's version of this under number 11 on page 90. Is public notice required for district committee meetings? And that's a bit of a complicated question. Public notice is only required for committee meetings if deliberations take place or the committee is authorized by the full board to take official action or render advice on matters of district business. So the question really comes down to what's the purpose of the committee meeting and what's going to occur there. And if it is something that you have a committee, like a budget committee or a finance committee that's going to review the budget and render advice to the full board on, here's the budget as we present it, that very well could be covered by the Sunshine Act. Easy way around it is just to advertise notices of when that committee meets. One of the districts at one of the earlier sessions mentioned, we just put it in our official notice that the following committees meet 30 minutes before each board meeting. So it's out there, you're covered, and you're not stuck there wondering, well, is this deliberations, official business? You can just avoid the whole issue by publicizing the committee meeting as part of it. But sometimes that falls through the cracks and districts don't realize that some of their committee meetings there may be a requirement to sunshine them. With 2 minutes left, I'll now cover the totality of the Patient Protection and Affordable Care Act, all thousands of pages of the law and tens of thousands of pages of regulations. I'm being sarcastic. The Affordable Care Act, that is also known in the public Obamacare. That is the law that was passed in 2010 that essentially is the most significant overhaul of the U.S. healthcare system since the 1960s. The law is extraordinarily complex, complicated, ever a moving target as regulations are issued, deadlines are delayed. It's not something that we would have the time, or frankly, I would even have the expertise to go through point by point, but we didn't want to ignore it as it's something that many of you may have questions about. So what we have here is some basic information for you on 91 and 92, and then we have a checklist on pages 1 through 7 there at the end on requirements that are coming into play right now, or in 2013, 2014, different areas of this law that have requirements that are coming into play. Now, a lot of these are going to be handled by your insurance carrier, if you're whomever you contract with for your insurance. So a lot of this won't be something you need to worry about, but to the extent that you had questions or wanted general information, we wanted to include that there. I wanted to clarify one of the things that you may be thinking about is the employer mandate. That is the provision of the law that essentially requires employers to provide qualifying coverage to all full-time employees and their dependent children, or face penalties for failing to do so. It's the mandate on employers to provide such coverage. The good news there is that applies only to employers with 50 or more full-time employees. So if you hear employer mandate, that should not apply to you unless you have county employees, or unless your district increases its budget to such that you would have more than 50 employees. If that occurs, good luck, but I don't think that's going to happen. Regardless, the employer mandate currently has been pushed back, the deadline. For employers with 100 or more full-time employees, it kicks in January 1, 2015. For those with 50 to 99 full-time or full-time equivalents, it's actually January 1, 2016. If you have less than 50 full-time equivalent employees, you're not subject to the employer mandate. So again, we provided that checklist more for your general information. It's certainly something to be aware of, but hopefully something that's being handled, not something that's in your day-to-day role as district managers. With that, it is 3 o'clock, and as I mentioned, I'm happy to answer any questions you have. That's the web address for our blog that I provided earlier. I recommend it because, again, virtually as soon as we publish stuff like this, it becomes dated because things happen. You can stay up to date through that blog in an easy and free way. And once again, I'm always happy this opportunity to work with districts and present to the districts. I've been doing this for a long time, and I always enjoy it. I hope you found this useful. Feel free to take, we have extra copies. If you want to take any extra copies of the materials, there's a couple extras up here. I'll stick around as long as you'd like me to answer any questions. Thanks again, and have a great day.